Ladies and gentlemen, welcome in here. Murder Church coming at you on the air. Week 9 of the Dr. Jack Kevorkian 1994 trial. Thanks for being in here. Please share this out. Let people know that you're hanging out with Publicly Buzzed this morning. Getting ready to come at you. Ladies and gentlemen, we are back. Murder Church is back. Welcome in here. Thank you all so much for being here. Making sure I have the bells in front of me so I do not forget to hit the bells this morning. Welcome in here, guys. What is up? Doing it. We're back. Has been a week since we were here live for Murder Church. Making sure I've got everything correct. Yes. Welcome, welcome, welcome. Please hit that like as you come in, guys. Really helps us out in the algorithm. Share this out. Let people know that you're hanging out with Publicly Buzzed per usual. You guys always do. Love you guys. Who's hanging out in here this morning? Dizzy. Oh, man. Here we go. Yeah. Pastor Steve in the house. Alligator Ashley. Debbie Blair. Charlotte. Poke Mom. Dizzy. I am not T-Pain. Miss Dina. Sheila Duffy. Holly Berry. Julia. Whoa. Holly Berry popped in. Whoa. Angie said it's so early. That is a rare one. She's usually not in the church. Julia Terranova. Dinah Doe. I think I said that one right. Dinah Doe, good morning. Remember, she told me that one correct in the Discord. Jersey Gin. Aspiring court reporter Sarah. Charlotte from the UK, from the future. Gambies. Welcome in here, everybody. Thank you all so much. Salvador Dolly Talk, what's up? Thank you all so much. Appreciate it. I am about to hit, because you can only start Murder Church one way, and that's with the bells, guys. I've got to do this right. This will probably also lure in Viv. The bells are out there, making sure they're working. Yes, nice. Yes. Oh, listen to those bells. It's been a week without bells. Are you kidding me? Jessica for Justice coming through here. Yeah, we are on week 9 again of the Dr. Jack Kevorkian 1994 trial. We just got done with Dr. Jack Kevorkian on the stand. Now we are up to, what are we seeing here first? WJBK News Operations Director Edward Rose takes the stand outside the presence of the jury. So it looks like it's, from the picture that I'm seeing, it looks like that there's maybe an interview outside. I see Dr. Jack Kevorkian's lawyer. So yeah, we're going to go see what's going on here, and we still got a little bit left to go here, maybe even a couple more weeks. But yeah, we're going to start this thing off. Again, thank you all so much for being here. Appreciate the hell out of it, guys. Again, hope everybody had a great weekend. There we go, baby. Bells in the chat. Bells in the chat. That's what I'm talking about. That's what I'm talking about, guys. Thank you all so much. But yeah, been a week without Murder Church. I'd hurt my neck. Came back better than ever. Let's freaking go. Taking care of myself. Not popping my neck anymore. So also very tired right now. I'm very sleepy. I, of course, didn't go to sleep till like 2 in the morning. But I'm here, baby. I'm ready to rock and roll. And let's start her up. Let me get over here real quick. The right screen. There we go. Bada bing, bada boom. Again, thank y'all so much. Oh, make sure the sound's correct.
Okay, the jurors are out of the courtroom. I'm informed there are some legal arguments to be made. I'd give a few minutes if anybody want to clear the courtroom now before we actually begin that. So if anybody want to leave now, you may, okay? All right, otherwise you may be seated.
I'm sorry. Hey, Shannon. My bad. I did miss Shannon there. And Adam's in here as well. Yeah, there we go. And Denise, we still have people popping in. Appreciate it, guys. Kelly Hill coming through here. Welcome, guys. Sorry if I missed anybody. Love you guys.
At the sidebar a few minutes ago, I was informed that the defense probably will have one other witness, and of course the prosecution may have rebuttal if that's proper, and I understand that there is an issue to be raised as to the possible rebuttal. Mr. Kinney, why don't you proceed with that?
Thank you, Your Honor. Could you just give me a moment?
Yeah, go ahead. Look.
Oh, good morning. Great value corn dog. Another great name. Alligator Ashley.
Your Honor, as the court knows, not only an opening statement by the defense, but also during the course of defense testimony, there has been evidence offered to the effect that the death of Thomas Hyde took place on Belle Isle, in Royal Oak, and not on Belle Isle. And as we have discussed before, notwithstanding the Attorney General designation regarding Wayne County, the issue is still one of a question of fact for the trier of fact. On Monday afternoon, we came into possession of a videotape, which I have here today, which I would like the court to see. It is a videotape from Channel 2, WJBK, and it is a tape from August the 4th, 1993. It is from approximately, I think, sometime.
Didn't say hi to Pokemon either. Good morning.
Time after 4 o'clock in the afternoon, and it is a tape of a press conference that was held at the office of, or outside the offices of Mr. Feiger. And in that tape, it indicates that Mr. Feiger, standing at the microphone with Dr. Kevorkian within camera view, right behind him, Mr. Feiger says to the press that Thomas Hyde died in Dr. Kevorkian's van on Belle Isle. And, Your Honor, I would call to the court's attention that we submit that the evidence as articulated by Mr. Feiger would be admissible under Michigan Rule of Evidence 801D2C as being an admission of a party opponent, as being a statement made by a person authorized by a party opponent to make a statement concerning the subject. Now, certainly this appears mostly in civil cases, but I would call the court's attention to two others. One of them being the People of the State of Michigan versus Von Everett. That's found at 156 Michigan Appeals 615. That being a case, Your Honor, in which an alibi notice that was filed by defense counsel was admitted under MRE 801D2C when the defense testimony offered at the trial was inconsistent with the alibi notice. And the Court of Appeals ruled that the notice that was filed by the attorney was viewed as a statement made by a party opponent, and the...
That's what Jay was calling him, Holly Berry, looking like Pat Sajak. We've all had our own people, though, that we thought he looked like.
attorney was certainly someone authorized by the defendant to make such a statement concerning the subject. I would also call the court's attention to a federal case, copy of which I'll supply to the court right now. I've supplied to Mr. Feiger. It's United States versus McKeon. It's a 1984 case that was decided by the Second Circuit Court of Appeals. That case, Your Honor, involved Mr. McKeon went to trial 3 times on a gun smuggling case. And at the third trial, the opening statement given by the defense attorney was different from the opening statement given in the second case. And the Court of Appeals ruled that it was proper for the trial court to allow the prosecution to introduce the defense attorney's second opening statement to show that there was, in fact, a factual discrepancy. And that is precisely what we're getting to in this particular case. Certainly, it is highly relevant and highly material to an issue in this lawsuit if the statement made by Mr. Feiger relates to where this particular crime took place, whether it took place in the jurisdiction or outside the jurisdiction. It certainly is something that goes to the credibility of the defendant, Dr. Kevorkian, as well as several of the defense witnesses who testified regarding to what the plan was, as well as Mr. Nichols' testimony regarding where the assisted suicide took place. I think the issue to be resolved is whether or not the court can be satisfied that Mr. Feiger is in fact an individual who is authorized or demonstrates that he is in fact the spokesperson or authorized to speak on behalf of Dr. Kevorkian. Certainly, looking at this case in its totality, Your Honor, I think we would all agree that if there is anybody in the state of...
I'm not even going to object to that.
Rolling in right now, Phil, Tayo Toys, brought in the van full of people. That's usually, I usually send out Phil and Adam in the mornings to go pick up anybody that's trying to get in here to the church, and this morning the van was having some issues. So welcome in, everybody. Pour it in right now. Welcome, 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 guys. Thank you all so much for being here at Murder Church. Starting out the plate early right now. Shannon coming through with is $5 enough to buy you a neck brace from Temu? Yeah, probably. Temo's the cheap one, right? Let's go, because I ain't even gonna lie to you. I legit thought about getting a neck brace for a moment. Like, it was that bad. It's still kind of weird. Like, I mean, I'm fine, obviously, but I still don't have full range of motion, and I'm just kind of working on that. Honestly, I'm like I've said on I think Thursday or Friday's show, I'm working really hard on just like self-care now. Like, I'm trying to like really think about my bones and stuff, because the older I get, man, I'm only 37 and I can already feel it changing. So I need to be a little bit smarter, and I'm not 20 years old anymore, and I shouldn't be fucking pulling on my neck. So Shannon, thank you so much. I love you. Give you some love up in here with the sound bites. This is my new favorite right here. Yeah. Thank you very much. Uh-oh. Holly Berry going to come in right behind it here. Hold on for a minute. Let me get up there. Let me get Donald Duck up on the screen real quick. What we got going on? I think it's Holly Berry coming through for one of her. I don't think it's her first Murder Church. I think she's popped through randomly before, but she's up this morning, it looks like. $4 holler coming through with the Holly Berry one. Let's fucking go, Holly. Oh my Lord. Coming through strong.
I'm telling you like it is.
I'm telling you like it is, baby. Yeah, I've got to take care of myself, because that freaked me out. Like, I've said it on here before, but when I pulled my neck, a pain shot from my neck to the front of my head that I've never felt in my life before. It freaked me out. It was excruciating. One of the worst, if not the worst pain I've ever felt. It was crazy. It freaked me the fuck out, and it lingered. Like, it wasn't just stagnant, it just didn't stay. But like, if I'd moved my head just basically an inch, it would kind of just start. You could feel the tingle, not the initial insane out the gate pressure when I first pulled it, but it would still just linger, man. And it freaked me out. And I went to the doctor the next day again. I got some pain pills. I got some muscle relaxers. I got a pain shot that day. Got a steroid, and and really have just been chilling out and trying to get back on track, which I mean I'm doing, because I mean I've been at work every day. I don't think I missed any work from it. Luckily, it's not lucky it happened at all, but Thursday night into Friday, which was the last day of the week, and I could take the weekend to kind of at least rest up. So I don't know. We're doing it, baby. We're here. We're getting older. Here we go. Dynado 420 coming through with the $3 holler. Thank you, Dynado. And she's absolutely amazing out here on Twitter, man. She is one of the most positive people, trying to help out everybody. Love it. That's what's running out in this whole thing, baby. I wanted to help out everybody. I love everybody. That's just this community that we're growing is unbelievable. And the true crime community in general has been amazing to Publicly Buzzed and the J Buzz Nation and all of us. But I'm telling you, this off to the side community that we're growing within the true crime community is something special, folks. So thank you all so much. Appreciate it. Love you guys.
I mean, you don't have to convince the court, Your Honor. I'm definitely empowered, and I'm not going to argue against it. You don't even have to waste your time on that.
I'm sorry, the part that he's speaking to now, or just the overall issue of whether or not this particular tape should be entered as evidence?
Sure.
You oppose it?
Well, the only thing that I'm concerned about, this case, that the Second Circuit case, which isn't applicable here in Michigan, but nevertheless, it stands for the proposition, first time in American law, that a opening statement, which was fully recorded under court proceedings, was admissible in the third trial. Mr. Kenny's 100% right. I've read the case just now, and the court acknowledged that for the first time in American judicial history, they were allowing that to be entered in the third trial. What the problem, and they say that they're doing something for the first time in American judicial history, but that they felt that within the context of the entire proceedings, the fact that they had the entire first or the opening statement under, that it was taken in a courtroom, that it was binding on the client, that a recorder appropriately transferred it and reported the entire conference or the opening statement, that they allowed that for the first time. Now, the problem that I have is simply twofold, Your Honor, and I think it's a unique issue, and perhaps I'm going to leave it to the court's discretion in this. Now, for the first time in American judicial history, we are not talking about the entering of an opening statement in a subsequent proceeding. We're talking about putting newspapers in, virtually. So Mr. Kenny might be entering tomorrow or last week's edition of the Detroit Free Press in as evidence. But also, so, I mean, that's a lot different than what this court was talking about. And more to the point, because I think I know the tape he's talking about, it doesn't have the whole context. It's a soundbite, and this court is well aware that soundbites can make it sound as if you're saying one thing when you're really saying another. And it seems to me that although the soundbite, I think... That's
the world we're living in now, right? How often do you see that in the news? And this is what I've found out a lot of times. It's something that I'm actually keeping up with. That's the only way I know, right? Because there's so much going on all the time. But you'll see some kind of headline. You'll see a headline that'll get you into a video or something. And then they'll be clipping out just a little hot take from someone. And that can be manipulated in so many different ways and taken completely out of context. And that's like basically the news, and people trying to have those gotcha moments now in all of media. And it's so gross. That's one of my least favorite things. And I learned that happens often because a lot of the things I truly am interested in and know what's happening in, and then you'll see somebody trying to take the shit out of it by just posting something, again, tagging it with a headline that doesn't actually match what they're saying, but they've taken just a small snippet out of context from something that they were saying long form. We need the long form today because you never know. And everybody's fucking trying to fuck everybody else up. Sorry.
Has me saying that I think it was apropos that Thomas Hyde died in a beautiful park setting. I don't think it was I think it was slightly taken out of context, and I'd like to hear the question that I was asked and my full answer. And I don't think that's on the tape. And so I think it's a unique argument, and I'm going to leave it to the court's discretion.
So you don't agree to it. You do oppose it, essentially.
Yeah, I mean, I oppose it not for the reason that Mr. Kenny, I don't deny that I am a agent of Dr. Kevorkian making statements on his behalf, which was one of the basis for the court's opinion in this case.
Okay, that's the part that you agree with.
Yeah.
You weren't agreeing to the whole principle of the admission of this. Okay,
Correct, Your Honor, because this court in the Second Circuit allowed it under a very assiduously controlled circumstance, and this was an prior opening statement made in court proceedings. Here, Mr. Kenny has a soundbite taken from a whole news conference that was played on WJBK TV2 Detroit, and doesn't have the entire context of what I said. And so, for the first time, I think an attorney's asking to put a soundbite in from a news conference that isn't being presented in total, could be out of context, and also hasn't been fully transcribed.
Does that go to weight or I mean to admissibility or to weight, Mr. Feiger? That's the concern here. I understand what you are saying, but
well, if it misportrayed, I'm not sure it's simply weight or admissibility. If you can take a soundbite and make day appear night, or night appear day, or black appear white, or white appear black, and change the entire context, that won't go to admissibility or weight. That'll go to evidence not fairly and accurately portraying what was really being said. And I think, therefore, because I haven't seen the whole thing, I'd like the court, and I'd like Mr. Kenny and myself.
Judge, I have the tape.
Yeah.
can it be done now? We
Sure.
got the machine back here?
Sure.
Why don't we help us get out the machine, Brian, and let's get that.
Judge, and if we could, just to make a record with regards to this, I have someone from WJBK who's here, and if I could put him on the stand just so that we can establish what this tape is and how it was compiled.
Let's go ahead and make that record too while we're setting up the machine then. This is a separate record. We're making the arguments here, so let's go ahead and do that.
Again, Your Honor,
Yeah.
just so I'm saying, there's never been authority for entering news conferences in court. Moreover, at the very minimum, you'd have to have the whole thing, so that it doesn't make it appear like it's something that it's not.
I understand your argument. What I'm doing right now is just getting the record made because I don't have all the information that I need, and I'll give both of you a chance to make a further statement about it. I can step down so you can just put it so everybody can see it.
Or affirm the testimony or about the matter not having
For purposes of this separate record, would you tell us your full name and your occupation, please?
Edward Rose, I'm the Director of News Operations at WJBK TV in Detroit.
And Mr. Rose, could you tell us, please, pursuant to a subpoena issued by the Wayne County Prosecutor?
Again, I don't question the authenticity. Yeah.
Well, hold on. All I want to do, Judge, is I want to make a record as to what's on this tape and whether or not it's edited or anything like that.
Oh, okay, that's fine.
Well, let's go ahead and do that. One of the issues you raised, Mr. Feiger, had to do with whether or not it's a complete tape.
Sure.
Okay. Mr. Rose, I'm going to hand you what's been marked as People's Exhibit, or Proposed Exhibit number 10 for purposes of this separate record. Are you familiar with this particular tape?
Yes, I am.
And would you tell the judge, please, how it was that you made this tape?
I made this tape after receiving a subpoena from the prosecutor's office asking for all broadcast tapes made on the day of August 4th, 1993.
And on that particular tape, how much newscast or how much videotape is on there?
What is on here, after a gentleman from the prosecutor's office came and viewed the tape first, and the part of the tape that is on here starts, I believe, well, I'm positive, it starts with the beginning of the news conference that started about 4:20 that afternoon in the middle of our newscast. At about 20 after 4, we switched live to this news conference and carried what's on this tape. This was live, that we carried live.
What's contained on that tape that you have in your hand right now, is that edited at all, sir?
Not at all. It's directly from what was carried on our air that day.
Well, wait a second. Can I ask you, didn't you just say that you edited that and cut it down from the prosecutor?
No, I cut the first 20 minutes out of the newscast that had nothing to do with the
where's the
Kevorkian
other?
case.
Yeah, but where's the other 20? Thank you for making that decision, but so you did edit that tape.
I was asked to put on anything pertaining to the Thomas Hyde case, and that is exactly what's on this tape.
And with regards to any material regarding...
Hey, first of all, that's a slick-ass white VHS tape. That's fucking pristine and gorgeous.
the Thomas Hyde case, did you edit any of that material, sir?
Of the material on this tape, no.
Don't the news broadcasters talk about Thomas Hyde on that tape?
We have the anchor introducing the live shot, and the reporter talking to you, as a matter of fact, is on this tape.
Okay.
Can we play the tape now, Judge?
Yeah, if I understand correctly, then what you didn't put on there was the first part of your news program leading up to that.
That's correct.
Live to that conference.
That's correct.
Excuse me, how long was the news conference?
We, I believe I put everything on this tape from where Dr. Kevorkian started. It's about 10 minutes, 8 minutes.
No, that wasn't my question. My question is, there was a news conference, right? The news conference started at a particular time,
Right.
correct?
Yes.
The news conference ended at a particular time, right?
Right, we did not carry
Okay.
the whole news conference.
Okay, so all you have is a portion of the news conference, right?
Yes, sir.
You don't know what questions were asked before or what questions might have been asked after this portion of tape.
Anything before is on here, because we have from the beginning of the news conference.
Okay, but you don't have what's on after?
That's correct.
So you don't have the whole thing?
No.
Okay.
Go ahead.
Well, by the way, in the whole thing, did I make a response in another part of the news conference about whether Thomas Hyde died in Bella?
All I have is what we broadcast on TV2 that day, and
So
that's
you
what's
don't
on
know
that
what
tape.
else I said, right?
No.
Okay.
All right, go ahead, pick up tape.
Judge, can you see?
I can see, okay.
Thank you. I'll be glad to answer any questions. Where's the start?
Is that the beginning of
Is
the
that
tape right
rewound?
there?
I didn't rewind it, no.
As we told you at the beginning of this newscast, Dr. Jack Kevorkian has assisted in his 17th suicide, and we go live now to his attorney's office in
I'll
Southfield.
be glad to answer a few questions, and I'm going to turn it over to Dr.
They're just
Kevorkian.
beginning to speak. He's introducing Dr. Kevorkian. Let's listen to him.
I decided to do this conference not for publicity. I don't care for publicity. I don't need it, and neither does what I'm working on need publicity. I did it to clarify the situation. I assisted Thomas Hyde in a merciful suicide. There's no doubt about that. I stated emphatically. I will always do so when a patient needs it because I'm a physician. I'm a pathologist, but also a physician. My main criticism in this is to the medical profession. Not doctors themselves, many support this, but the politicians who run the profession, who call themselves physicians. They're politicians first, businessmen second, and physicians third. They ought to be ashamed of themselves to have human beings like Thomas Hyde suffer immensely, unable to move any muscle, cannot speak, cannot swallow, have pain in addition to all that, and they turn their heads because we've got to discuss this a little more. Now they have a meeting planned in a couple of days with ethicists, lawyers, politicians, philosophers, legislators to talk about what? The world knows there's a need for this. The talk is senseless, pointless. There's nothing new to be said about this. So I blame first and foremost the medical, organized medicine. They are the culprits in this because all they need say is, this is a needed medical service, this is how we will do it. We don't need any law to tell us how to do this, like we don't need any law to tell us how to do a heart transplant or a gallbladder operation. This is our business. We know it. And it has nothing to do with religion, philosophy, or ethics. It has to do with medical service. And only physicians can do that. Nobody else. Nurses, physicians, paramedical people. physician assistants. They will do the deciding when the patient needs the service. The patient is the ultimate decision, autonomy. So you have two things involved in this, not law, not philosophy, not ethics. You have medicine and personal autonomy, and that's all that's needed. You don't need press conferences, you don't need laws, you don't need any kind of persecution or prosecution or arrests or fingerprinting. You don't need any of that. A civilized society would face it squarely and do it right. So my criticism is first to medicine, almost equally harsh against the authorities who run the governments, who try to dictate to the people based on their own personal prejudices and override personal autonomy. These are the ones who are to blame for all this controversy. And I state emphatically, any real physician would help the patient who needs it despite any other consideration. But as Hippocrates said in the old days, physicians, like in those days, today too.
The man right here, Dr. Jack Kevorkian. No one has the balls to stand up like he did. Come on, this guy's amazing, bro.
Physicians are many in name, but few in reality. So my challenge is to the medical profession to stop talking, stop all this jostling, get down to business, declare that it's a medical service, then it's covered by law, like all medical service, and then you sit down and lay down the guidelines and the rules how you'll operate, and you'll change them every week as you learn more and more. No law can do that. I appreciate this opportunity to explain my position and exactly what the situation is. Thank you. I have one other announcement. Mrs. Hyde has requested, and I support it, there is nothing she can say to anybody. So she requests that she not be bothered in any way with questions or any kind of request for interviews. And I told her that I promised her that I would make that announcement, and I agree with her. There's nothing she can add to this story, so please be considerate of her period of grief. Thank you.
I anticipate some of your questions. I'd like Dr. Kevorkian also to talk about Mr. Hyde's suffering and what he suffered from. I think it's appropriate as a medical doctor that Dr. Kevorkian talk about his physical condition and what led him to make this decision. Go ahead.
That mic stand down.
Sure.
A little bit so we can see his face. There. Thank you.
Adam Malone coming through here, gifting out 5, count them, 5 memberships. Holy cow. Sheila Duffy grabbing one. 9 Lives Mama, new name. Okay, Sana Luke. Hope I said that one right. Probably butchered it. Catpool and Lollipops. Welcome in here, everyone. Thank y'all so much. We love lurkers hanging out in the background. Please, beers in the chat for new people coming through. Got some coffee drinks since it is a little bit early. Maybe a little something else. You never know. You never know. I want to do a plug real quick for my Patreon. Anybody that's not on the Publicly Buzzed Patreon, get on the Publicly Buzzed Patreon, because there's going to be a lot of content that I'm posting on there that I can't actually share on the YouTube members only, just because of their guidelines. So you're going to want to be on the Publicly Buzzed Patreon page moving forward. Again, that's counting multiple different things that is going to be happening. But yeah, thank you all so much. Adam Malone, who is also going to be coming on here as a guest soon. I'm going to see if I can make that happen this week. That'd be dope. Maybe get him on here for a Thursday show. Doing something with the news. Me and him just talking. Hell, honestly, all three of us, even if we had somebody else, just bullshitting, I think will be interesting, because it's always super fun to talk to Adam on the old twit box and in the chat here. Thanks, brother. Appreciate it. Yeah, and turn on your gifts if you haven't, because you never know when some of these generous, amazing, nice people will give out gifts. You're going to want to have your gifts turned on here on YouTube, brother. Thank you very much.
Get on my camera. Well, you all know what ALS is, amyotrophic lateral sclerosis. It's a disease of the spinal columns, lateral meaning the side parts of the spinal cord, sclerosis meaning scarring. It's a scarring, the specific scarring of the nervous system. Amyotrophic means the muscles wither away. Mr. Hyde's disease was unusual. He was diagnosed in August of last year, and he progressed to terminal of August of this year. He could not speak. It was unintelligible. He could make noises, but he couldn't. You had to be very careful and listen closely. Only those closest to him could understand him. He had difficulty in swallowing and in breathing, especially when he's lying on his back. Mrs. Hyde had to turn him over on his side constantly so he could breathe easier. He
couldn't move at all. All he could move was a little on the left hand, just a short movement like this, and he couldn't straighten his fingers out in that hand like this. Just absolutely impossible. He couldn't raise, when I saw him a month and a half ago, he couldn't raise either arm more than this level. Now this one was completely paralyzed, and he couldn't walk, he couldn't stand up. Very difficult. With a walker, he would walk about a yard in about 5 minutes, I think. He was terminal. People criticize and say, well, that's not cancer. They think only cancer is terminal. Any disease or affliction that limits life.
Yeah, maybe education. We needed this entire thing for an education purpose. Let people know. I've learned something through this already. Like, people need to know about some of these other debilitating diseases out here that are absolutely wrecking human beings' lives to really have no life anymore. If you're just laying in a bed being rolled over by your wife, who also's life is now completely being destroyed, she can't have a normal life or have a job because she's got to take care of this person. And I'm sure she wanted to, but at the same time, once you get to a certain point, if that person wants to check out, they should be allowed to. In this situation, in this type of situation, they can't move. They have trouble breathing. They're afraid they're going to choke to death and die just eating regular food. Come on.
From its natural ending is terminal. Alzheimer's is terminal. ALS is terminal. Multiple sclerosis is terminal. And even strokes are terminal. So that criticism is not valid. But he had a very severe case, very rapidly progressing, and in 1 year went from diagnosis to almost terminal.
Thank you. I'll be glad to answer any questions. Again, Dr. Kevorkian isn't going to be answering any, and Heidi Fernandez isn't. Yes.
Jeffrey, what does Dr. Kevorkian mean when he says he assisted in the suicide? Can you or he explain more specifically?
You have all been covering this story now. Heidi, you can come in here. For now over 3 years. I think it's significant, and I think it's apropos that Thomas Hyde died in a beautiful park setting in Belle Isle in Dr. Kevorkian's what's been described as a rusty old white van, but actually is truly a really kind of nice van, and there's nothing ignominious about that. Dr. Kevorkian has been utilizing his method of assisted suicide with regard to use of carbon monoxide for quite some time, and you're all familiar with that. And that is exactly the method that was used in this case. And again, as Dr. Kevorkian's press release indicates, if the governor or the legislature wish to try him before a jury of his peers,
involvement in this suicide, the 17th assisted suicide, Novi resident Thomas Hyde, diagnosed with Lou Gehrig's disease, committed suicide this morning, as Dr. Kevorkian said, with his assistance. We'll continue to follow the story, and we'll have more from this news conference on Eyewitness News at 6. Reporting live from Southfield, Jennifer Howe, TV2 First News.
Okay, thanks, Jennifer, for that live report. And of course, Dr. Jack Kevorkian saying today that he indeed assisted in the suicide of Thomas Hyde. That is possibly a direct challenge to the state law now on the books. But much more with First News continued. Stay with us.
Your Honor, I would indicate for the record, the court having had the opportunity to see the tape, I believe that the evidence certainly is relevant. I think it's appropriate rebuttal evidence, and I think the context in which the comment is made clear in the tape, and I would request at this time to be allowed to show it in rebuttal.
Okay, let me get that television. That's mine. Can you move that back, Brian, a little bit, please?
Can Mr. Rose stand down, Your Honor?
Pardon me?
Do you need Mr. Rose?
Do we need any other testimony from Mr. Rose?
No.
Okay.
Thank you.
All right.
My only response, Your Honor, is this is a not only unique request, unprecedented request, never before allowed in Michigan jurisprudence, but even when it was allowed for the only time in the history of American jurisprudence, the whole thing was there. We don't have the whole news conference. I don't know what else I said. And we need to have the whole thing. And I think Mr. Kenny is also proposing to pay just a little bit of part of this one. So we might as well put in news clippings.
Well, I suppose Even news clippings, I guess, could be of some...
Damn good point, Gambies, yeah. Like, why do we not do stuff that we know works? Like, we have somebody else come through and they want their idea to be the correct and right idea to be used going forward. So they're the person that made it happen. It's all about control. It's all about narcissistic mindsets in a lot of ways, in a lot of these cases. Something that Dr. Jack Kevorkian does not have. I don't get a lot of things, man. Like, I don't know. The state fucks everything up. That's one thing that I do know. I'm not a fan of basically anything that's coming from state level. It's usually trash, and they want to control people's lives. That's literally what's happening in a lot of cases, and it's bullshit. And especially in a case where if you or your family member, a loved one, someone that's close to you is dying in this type of position, and in this case, they can no longer really even verbally make the choice, right? They can let you know, but they can't actually state that. He had to sign his name. So if you have family members that are saying, listen, this guy, my husband, my dad, my brother can't roll over, can't move properly, is not living a life that even wants to be lived at this point. They want to go out with dignity, and they want to go out on their own terms and their own means. That's the only thing they would even have control over at that point in time. It's crazy, dude. This shit, it burns me up, quite frankly.
Significant based on the context of those. I suppose if the same comments had been made in an interview, I suppose it could amount to the same thing. But one of the things I think that when I give a chance to speak here, I suppose, is certainly there can be room for error or human error, I guess you would say, when we have someone that hears something and then writes about it. And believe me, I can speak personally of many times that I've been misquoted, and say one thing and that comes up different, when it appears, in print. But it's certainly difficult to argue with a video tape as to whether or not there's the inaccuracy there or something like that merits a closer scrutiny, I suppose, than what you get on a video tape. The same kind of argument is parenthetically stated as...
I agree with that also, Adam. And I mean, there's a fine line there, I guess you could walk with a lot of people. There are people... you think about Dr. Jack Kevorkian. You think about him out the gate, you're thinking, oh, he's helping people commit suicide. Anybody could just walk off the street being depressed and ask him to commit suicide. No, it's not like that. Okay, and I'd say walk the fine line with what Adam just said, basically because, you never know. Maybe you'll have somebody that's just a little bit down. Maybe they don't really want to kill themselves. Today they may want to kill themselves, but in an hour they may not want to kill themselves if they have a conversation with somebody. How many times do you hear about the stories of someone being pulled down off of a ledge and then later thanking that person because I didn't actually want to die? So, I mean, I understand that situation also, but later in life, as this thing keeps on ticking away and people get, it's rare that anyone gets out of this thing without getting some kind of disease that takes you out. That's the sad fucking reality of it. That's what sucks, healthy living. As I'm getting healthier, I was talking to somebody in the line at the store, and this is interesting just because, I just had the neck issue, whatever, and she was a 70-year-old lady, and basically she's talking about how her husband's friends, he's always lived just how he wants, lives a normal life, eats what he wants, drinks what he wants, whatever. Fine, never had any issues. All of his friends who were, bodybuilders, worked out, ran marathons, ended up getting diseases and died. Her words. You never really know, is what I'm trying to say. Take care of yourself 100%. Always take care of your body and your mind and try to make it to that next day. But we have no control over this, truly. So if you end up in any kind of position or situation that you, again, don't have control over that next day because of some debilitating disease, bro, you should have the option yourself, because it's your body, to check out.
It's been put forth, in certain circles that when you have confessions and so forth, introduced by prosecution of defendants, that is everything is better served when there is a videotaping of that as against an officer writing down something as to what was said. So I say that only to suggest that certainly a videotape has a certain a difference in meaning, I suppose, than you may have with the written matter. Now, obviously, I'm not so naive to know that one can tamper with and edit and redo tapes and all kinds of ways with the high tech different kinds of devices and technical devices that can be used, for that. The only concern I would have in terms of this being introduced is whether or not there was some indication that it was edited in some way or tampered with, that it would tend not to show or speak the truth of the matter, that is there. That would be my immediate concern. So let's start talking with it about that.
What did I say afterwards?
I don't know.
Well, that's my point.
I understand that's your point, but I'm not sure that your point is of significance in terms of what you said. That's right there. Maybe you did say something else.
It is when you're the proponent of evidence, Your Honor, that for the first time asks a Michigan court to put in a soundbite from a news conference, and the only support you offer for it is a Second Circuit Court opinion out of, I believe, New York, that says that they would allow a prior opening statement to go in, first of all, in its entirety. Here, we're not talking about that. We're talking about Mr. Kenny being able to put in one question and one answer from a news conference that isn't in its entirety. What did I say for the next 45 minutes afterwards? I might have said 50,000 times that I meant that it was nice that his body ended up in Belle Isle. I have no idea, frankly, what I said. But never before, has any court felt that in terms of evidence and an accurate portrayal of evidence that a prosecutor could come in with a soundbite of one question out of a 45-minute news conference and play it to the jury and say, here's proof. Even the one case that he cites, the court went out of its way to document that the thing was accurate, that the entire transcript of the entire opening argument was present, so that there could be no ambiguity. And then it's only because it was within a court proceeding and a court stenographer had taken it. I know that there must be 10,000 court cases with 10,000 press conferences. Never once has a court before ever allowed such evidence in. And even if the court was even thinking about allowing such evidence, you would have to then say, under what circumstances would such evidence be allowed in? How could the court possibly allow in one question from a news conference that might have lasted for 45 minutes and the whole thing isn't there? If the court needs guidance, I ask the court to read the case that Mr. Kenny just gave you. The court went out of its way to explain how, in order to protect somebody's rights, they weren't about to let just any prior statement of an attorney in. This prior statement was taken in a court proceeding under oath. This court didn't even suggest that it was going to start letting news conferences in, let alone
Wait a minute, the attorney wasn't on the oath when he made the opening statement, was he?
No, but it was because it was an opening statement made in court, and it was the entire opening statement being transcribed accurately, and the whole opening statement went in, so that the proponent didn't say, the court didn't say that the proponent was allowed to excise 3 paragraphs out of the opening statement and present that as evidence. He was required to present the whole opening statement, because the whole opening statement might be the 3 paragraphs in the beginning, or whatever part the proponent wanted, might be misrepresented or further explained later in the opening statement. Here, there's no such protection. I'll tell the court, I have no idea what I said, but under those circumstances, that's just too bad. You don't get to bring in sound bites from press conferences and claim that I need this evidence and sorry I don't have it. That just won't satisfy the criteria. So I asked the court, in its wisdom, take a look at the case that Mr. Kenny gave, because it talks about the protections afforded, and it specifically addresses the completeness doctrine, because we would be turning everything in its ears to present one question and then leave the entire rest of the press conference out, where I might have dealt with the subject 38 times.
Any other comments you want to make, Mr. Kenny?
No, Your Honor.
Okay.
I did not want to cut him off there. Absolutely pissed off. But I did want to shout out right now, Gamby's passing the plate, $5 holla. I'm a bad man. Let's go.
Shit.
Thank you, Gambies. Absolutely appreciate that. I understand why he's so freaking upset, though. Like, watching this one, I feel it, man. It gets in you.
In spite
Fire
of let me just phrase this way. I never even anticipated at the beginning of this particular trial and all the moments in time, leading up to it. First of all, that it would get to trial, prior to the Court of Appeals being able to make their decision. I certainly never anticipated, the tack or approach that was taken to this case by the prosecution to strike the defense opening statement. And it seems that what started off to be a somewhat erring and being able to put forth to the test of a trial the issues that surround the entire issue of meticide or physician-assisted suicide, that all of that possible lofty principles and whatever else that may be involved with that are now kind of clouded by the issue of whether or not there's a proper jurisdiction. Now, that's not to be critical, mind you, because any defense attorney that tries a case has to make every effort to defend the case on whatever means there may be. But I mention that because this particular issue regarding jurisdiction has certainly taken a paramount significance in this particular case, and it's obviously, in the context of this case, based on the evidence, certainly it becomes important. However, in terms of the tape, though, that's been shown here, the only concern, as I said, would be if I had some concern about whether or not it was edited or tampered with in some way or made to look like something that it isn't. It may not be the entire press conference that was there, but it's for instance, it's easy to take a part of a transcript of someone giving testimony at a different time and point back into it, say on page so-and-so, line so-and-so, that you say this. And it's not whether or not there are a whole bunch of other things that may be present in that particular trial or transcript, whether or not that particular specific area is objective is to impeach or show something different that is a matter of record. That becomes the focus of that, and in fact, it's not really doesn't amount to the substantive proof maybe in that context, but it certainly becomes important to show that something different was said based on that particular record. It may not, I agree, yes, it isn't a complete conference, and when one looks at that, I think one could also argue that the subject matter gets into something altogether different after that particular statement is made. But accepting that there is no objection or agreement, more or less, that Mr. Feiger was a spokesman in a sense, I do not and will not deny the use of this merely because it does not contain a complete interview. I think that the context of it and what's shown there is sufficient to show that something different was said, that it wasn't edited or tampered with, and that that particular objective, is obtained by that particular tape. Beyond that, Mr. Feiger, it's kind of like I know probably I was a defense counsel for almost 10 years, and sometimes you anticipate, things and things come up later in the trial, that you may or may not know or anticipate, and it can really strike down, your whole approach. But that's one of the unknowns, I guess, about trials sometimes. But final comment?
Rule 106 doesn't allow this. When a writing or recorded statement or part thereof is introduced by a party, an adverse party may require him at the time to introduce any other part or any other writing or recorded statement which ought in fairness to be considered contemporaneously with it. And I cite to the court People versus Warren.
hold on, Mr. Fike, but there's a difference between saying that there might have been something else that wasn't put into that writing. If you take the context of the writing itself, we got the tape. The tape is the item that we have here. The entire tape can be shown. That's what's complete here. The fact that the whole thing wasn't recorded is not, I think, a moment, because we're not talking about whether or not, if we got a writing or whatever, that every possible thing that could have been said was there. If the writing is 4 pages, or if it's 2 pages, and you got that whole writing, that's what the writing is.
But it
you
was
got a
recorded.
tape here that contains, what was recorded at that time. That's all we have.
But no, that's not correct. It was recorded. He just can't get the whole recording, so he wants to show a snippet of it, because all he can find is what TV2 preserves in its archive.
Shit, Brooklyn just came through my text here, sending I'm not sure if it's a Cash App or what it is. Let me see. But thank you very much, Brooklyn, for sending me $15. Holy shit. Let's go. Bet that was on the old Venmo machine. Hold on. Yep. Oh, yeah. That's what I'm talking about, Brooklyn. $15. Let's go. Thank you, Brooklyn. Appreciate that. Hell yeah. Happy Sunday.
It was recorded. There was recording of it. And may I just state for the record, People versus Warren, 65 Mishap 197. Trial court committed reversible error in excluding portions of tape-recorded statements by defendant shortly after alleged crime for which defendant was accused, rather than admitting the entire recorded communication, even if the excluded portions were self-serving as the defendant. There's further cases of People versus Crosby, 19 Mishap 135, and People versus Bowen 170 Michigan 120, where the prosecution introduced in evidence a confession of the accused disclosed by part of a conversation, accused held entitled to prove the entire conversation bearing on the confession. That's been the law for 100 years. Now, he's required to prove my entire statement, not just pull a part of it out and then say the law of completeness. The doctrine of completeness under Rule 106 requires the whole thing to be in evidence. And if the court is ruling against me on this, which I don't think it should, I'd like the court to rule on the doctrine of completeness as to the portion that's planned to be played. Is he required to play the whole thing? Because I see under that doctrine, he's got this tape, I want the whole tape played.
Okay. Any other response to that?
No.
Okay.
No, Your Honor.
All right. I have no problem with the entire thing being played.
Thank you.
Okay. All right. See you tomorrow morning, 9 o'clock.
Judge, I have one other matter that I'd like to take up. Could we clarify on the record, if we could, whether or not Mr. Feiger wants Mr. Rose back for...
Oh, yeah, I'm sorry. Yeah, do we need any record?
Stipulated to its authenticity.
Oh, okay,
Okay.
good. Then we won't need him. By the way, the clerk is going to give you a copy of the proposed elements and instructions there for you to look at and to make any modifications.
I do need him back, Your
You do
Honor.
need him back?
Okay.
Mr. Rose? Is he? Huh?
He left.
He left already?
Okay.
Can you be able to contact him? So we may need him back. Okay.
Okay.
I'll need him for tomorrow.
Yeah, let's get him in here then, so we can proceed with this in the morning. Okay. Anything else, Mr. Kenny?
Yes, I did. One logistical question, Your Honor, with regards to that designation evidence. How is that going to be made known to the jury? Because I think that's something I need to argue.
Frankly, I don't know or think, whether it should be brought before the jury, and I tell you why, and I'll hear more on this tomorrow morning after I get a chance to think about it and have you think about it. What that to me does is, as a matter of law, you might say, where the Attorney General designates, this county as the place, and that's what's in the information already, which is all a part of this case. It just now have the Attorney General saying that's it, and I think that it could be very confusing to the jury to think that the Attorney General has now officially said that this happened in Wayne County. It just gives you, I think, the official formal document or order to say that it can be done in Wayne County, but I don't think that should have any effect on whether the jury has to still decide that factual issue. You understand what I'm saying? Okay. How do you pretend, or what would you argue, would be the reason, for saying that?
Well, Your Honor, my understanding is that in previous cases, that the issue goes to the jury, and that the jury is told that they are to determine whether or not it happened in Wayne County, or they are to consider whether or not the Attorney General has in fact designated Wayne County as the place for this to be prosecuted. I mean, it makes it a very awkward circumstance, I would agree. But if the jury isn't told something, then the designation becomes essentially worthless.
Well, it may be very worthless in the sense that what the jury need to know about it, but it gives the official, I can't think of the right word, the official order or whatever you want to call it as to what county is to be designated by that order. But it does not remove, I think, by law, and because we have that order, that automatically the jury is told that, well, now that the Attorney General say that this happened in Wayne County, you are foreclosed considering that issue because it is mentioned as one of the elements, in the charge.
Right. Well, think about it in this context, though, Judge. Aside from this particular type of case, let's say there was a homicide case where they had no idea where the murder took place, and a petition is made before trial, and the Attorney General designates Wayne County as the place for the case to be prosecuted.
And what
Clearly,
that means,
the jury is told something.
I don't think so. Well, if that's in the case, tell me about that. And I looked at the case of myself the other day where that did happen. The very same thing happened where there was a homicide where the person may have been in Oakland County and then ended up being found dead, and last seen in Oakland County being found dead in Wayne County and so forth. But at least what the way I see that designation, that's simply saying by the Attorney General, well, if there's some quibbling over where it should be tried, that kind of decides more or less the issue of where it should be tried, but not essentially foreclose by a matter of law the issue to the jury. In other words, if there was some question about this before the prosecution, started, and then Oakland County said, well, we should do this, and Wayne County said, we should do this, others said, well, I don't want to, then the Attorney General stepped in as kind of a referee and said, hey, I'm saying it should be tried in Oakland County, I should be tried in Wayne County. And then that makes it official as to allegedly where it occurred and where it should be tried. But that still may leave the issue, from my estimate at least, that it's an issue that still has to be shown, by the evidence. Now, I understand
but what if it
the
can't
problem.
be shown? I mean, when you look at the statute itself, Judge, the statute talks about impossibility.
Of what?
Okay? Of where the crime occurred. If you look at
in terms of where it should be tried, not in terms of whether or not that proves that the crime happened there.
Your Honor,
am I right?
No, I think it talks about if it's impossible to determine where it occurred.
well, he just made the argument that he's got evidence that he can prove where it occurred.
Let
And
me just get the word here, and then we can be sure about it.
you can even take a look at the order. The order doesn't say I take away from the jury. I think we should take a look at the order.
I tell you what, I thought I had that. Did we put that in the file? Okay, it's in the file. But you see, my reading of that is as I said. Now, what I will do is give you. I need a copy of the statute. That's what I was looking for. The statute itself. I'll give you a chance to argue this to me and bringing this in again tomorrow. But I think you can see what my thinking is, and that's how I read this as simply letting the Attorney General decide where there might be some quibbling over what county it should be tried in, to step in and decide what that county should be, but not essentially, to foreclose, proof. Regarding that. I understand it is something of a quagmire there, because then, well, anyway.
It's just a loose end that I think we need to address tomorrow, Judge, and I was concerned about it from the standpoint of whether or not I have to do something on rebuttal, or whether the court's going to fashion an instruction to the jury, or, if we mention it in closing argument, the jury's going to be scratching their head saying, well, what in the world is he talking about?
Well, see, it was my thinking that it probably should not even been mentioned as to what the Attorney General did, because it's not a factual issue as to what the Attorney General did, and it just simply settles the question of where the case is to be tried. That's how I read it. Now, if we want, I don't have the statute. I thought I had it handy, but we can look at the statute again. I'll find my copy of it, and I'll let you address that again.
We can do that tomorrow.
First thing in the morning, okay?
Can we approach the bench?
Sure. Yeah.
Right. Moving right along into the next one here. Heidi Fernandez, the fiance of Thomas Hyde. Oh, wow. This one's going to be difficult, I bet. So, trigger warning just for the content that's probably going to be talked about. Tears could be coming. All right. Let's rock and roll. Keep moving here. Hit you with a little bit of a Murder Church stinger, though. Again, I appreciate everyone for hanging out on Murder Church. We are back, baby. Coming at you February the 4th. Wow, we're already into February. We've already made it through 1 month of 2024. What the actual hell is going on? I do not know. But yeah, let's get into keeping this thing moving down the road.
Get your name for the court and jury.
My name is Heidi Fernandez.
And where do you live, Ms. Fernandez?
In Novi, Michigan.
And who do you live there with?
My daughter, Carmen.
And who is the father of Carmen?
Thomas Hyde.
And how old is Carmen?
She's 23 months. She'll be 2 on May 10th.
Okay. When did you first meet Thomas Hyde?
I met Tom in 1988. It was in August. We were introduced by a mutual friend.
By the way, are you presently employed?
Yes, I am.
What do you do?
I work in graphic arts for a printing company.
Okay, and how long have you done that?
For 8 years at the present company that I'm working with now.
Okay. Do you have any other children besides Carmen?
No, I do not.
Okay. When you met Tom in 1988, did he have any health problems at all?
Not at all.
And what was Tom doing at that time?
He was working in his landscape work, doing some tree removal, climbing trees and removing huge limbs, climbing trees that were maybe 30 feet high, and he'd be the only one up there.
How would you describe him in terms of his...
Dude, I just turned 37 in October, and I swear to God, that's the age where it everything just tipped over. Ever since I've turned 37, I've had a fucked up knee and a fucked up neck, so...
Physical prowess.
Beautiful. He was a beautiful... he was a beautiful man, physically, and to me, mentally. I fell in love with Tom.
How did, that was going to be my next question. How did your relationship develop?
Well, we had both been involved in other relationships at the time. Neither one of us were married, but we were involved with other people.
And it was!
We fell in love immediately, and we had decided, well, we had a brief affair, let's say, for 4 or 5 months, and had then spent a couple years apart prior to the last time we were together, and we moved in together immediately after we had spent that time apart.
When did you move in together?
In March of 1990.
Okay. And where did you move in together with?
Well, I was living with a friend of mine in a condominium at the time, and Tom moved in there, and then a month later we got our own apartment at Innsbrook Apartments in Northville.
Okay. Is the place that you live now different than where you first lived together?
Oh, yeah.
Okay.
Yeah, we got a handicap apartment when Tom started to get, things started to get harder for him to do.
Okay, so you first moved into an apartment in Northville, and how long did you both stay there?
We stayed there for 7 months.
When was Carmen born?
She was born in May of 1992, on Mother's Day.
You moved into the Northville apartment in what year?
1991. 1991.
Okay. And how long did you live there?
7 months.
Did you continue to work in graphic arts?
Yeah. Mm-hmm.
Did Tom continue to work in landscape architecture? Tell us a little bit about him and how your relationship developed and what sort of person he was.
Tom was an extremely physical person. I've told people before he would have lived outside if he could have. That's one thing that we had in common. We both like to hike and be outside constantly as much as we could. I remember we always slept with windows open, and we camped a lot. Our relationship grew, I think, a lot in the fact that we were both been somewhat irresponsible people, having no responsibilities to worry about. We were free people, and we lived that way. We enjoyed life that way, and that was definitely a very mutual attraction between the two of us.
What type of person was he in terms of wanting to control his own, I guess, ability to live life the way he wanted to?
Tom was always in control. There was no doubt in my mind that he enjoyed the control. He was fascinated almost by his control over he could do anything. He could actually do anything physically.
Was that important to him to maintain control over his life?
Of course.
How and why?
How and why? I think I can answer that best by noticing when he started to not be able to do that. That's when I actually realized how
amazing. Actually,
much he did.
So strong. I'm gonna cry even thinking about what she's been through.
Just lived on that, the ability to do anything he wanted to do.
Why did it take the time when he began to decline for you to see the importance to him of his ability to control his own life?
It was so natural to him. It was just natural. He never thought about it. He was okay physically, mentally. It never occurred to him that something like that would ever be not a part of his life.
Did he ever express any desire to you before he got sick to commit suicide?
Never.
Did he express any desire to you afterwards
Never.
to commit suicide?
Never. Never.
At any time up to including the day he died, did he ever express anything
Never.
like that to you? Do you think Tom wanted to commit suicide?
No, I know he did not want it. It's not a thought. I know he did not want to commit suicide.
Did he commit suicide?
Not in my eyes.
What did he do?
He ended his suffering.
We know
that word, puts a whole different spin on it. And I'm not going to say it, but I mean, fuck, dude. He put an end to his suffering.
By ending his suffering, it caused his death. Did he know that would happen?
I don't think that was important to him. I think what was important was that he was not going to suffer. Every day that Tom got up, he lost a little bit more of his life, a little bit more of his physical ability. Every day that he woke up, he didn't know what he was going to do with his hands or what he was not going to be able to do with his hands that day. What was I going to have to do for him again that day? He hated being a burden on me. He hated watching his child grow while he wasn't growing.
When did you notice that he first was becoming sick?
When did I personally?
Yes.
In May of 1992. It was May 11th. I remember the day because I had Carmen, and he came into the hospital he brought me a carry-out.
Carmen was born in May?
She was born May 10th. This is May 11th.
Okay.
And he came in the hospital and brought me some food. And he had stopped at a restaurant where we frequented. We knew the owners, and they knew I'd had a baby. So they bought him a drink while he was waiting for my food. And he came down to Sinai and brought the carry-out. And when he got there, I could smell alcohol in his breath. and his speech was so slurred. And I was like, oh, you're driving like that? You're driving our truck like that? And you come to visit me in the hospital? And he says, Heidi, honest, I didn't even finish the drink. This is nothing, you know. But his speech was slurred. At this time, this is when we started to think there may be something wrong.
Why, just because he had slurred speech, did you start to think he had something wrong?
Well, prior to that, we had seen these fasciculating, these muscles fasciculating up in his upper chest here. Up until this point, it was funny. We looked for these fasciculations.
Why do you call them fasciculations? What is that?
It's a rippling of the muscles, and they would constantly be moving. I attributed it, and so did Tom, to his overworking his muscles. He worked so hard. He took every day, he got up every day at 5 o'clock, made coffee, and went outside. Even if there was, he found something to do outside every day, even if he wasn't working. And I always thought, oh, you're working too hard, and your muscles are just like not calmed down yet. So I didn't attribute that to any illness until May, when the fasciculating had started to be on the other side now, and it wasn't coming and going anymore like it used to.
What came first, the fasciculations in the muscles or the
Yes.
slurred speech?
The fasciculations in the muscles.
After you noticed the slurred speech and you got out of the hospital after having Carmen, what happened next in terms of his health?
Well, we were quite taken by being new parents. We were adoring our little child, our daughter. She was definitely the apple of Tom's eye, and we were quite taken with that, with being parents of a newborn.
Mm-hmm.
I don't think you understand unless you've experienced it. I think I was home for maybe about a week. Tom was going to work periodically. He wasn't working a lot because he had to come home and make sure I was taking care of the baby okay, you know. Mm-hmm. And so this one afternoon he came home from work, and it was about 1:30. It was a beautiful day, and I'm thinking, wait a minute, you work in landscape, it's a beautiful day, it's 1:30, why are you here? And he was walking up our walk, and I was excited because I thought we would be able to spend the day together. And I opened the door and I said, why are you here? It was just kind of an eerie feeling. And he started crying. And he said, I couldn't hold my hammer today, Heidi. And he couldn't squeeze it in his hand. He couldn't tell his hand to squeeze the hammer.
What did you do then?
I said, Tom, we're going to go to the doctor. This is it.
Like that moment from day to day.
I don't want to fight over your slurred speech anymore. I was accusing him unjustly.
Had that continued?
The speech, yes. The speech was the first to go. As far as I know, Tom had been experiencing other things before he told anybody. He was so afraid. When he would spill over on his motorcycle, he didn't want to admit to anybody that it was because his leg wasn't strong enough to hold him up. He was so afraid that if he admitted it, it was going to be true. He was afraid long before he was diagnosed.
When was this time that he came home and he
don't acknowledge it, it ain't true, right? That old thing in your head.
He confessed that he could no longer hold a hammer in his hand.
It was, the 10th. It may have been around May, between the 17th and the 21st, sometime in between there. I know it was before my birthday.
What did
and
you
my
do?
birthday's the 24th.
What did you do next?
I called my little sister and asked her if her husband had a doctor, or did they see a doctor. Tom has never seen a doctor, unless he was in emergency rooms getting stitches from getting cut with chainsaws and all kinds of stuff.
Did you get a doctor?
We found a doctor,
Who was
Dr.
that?
Blum, in Novi, I believe. It's at 10 Mile and Haggerty.
What type of doctor is Dr. Blum?
I believe he's a DO, general practice.
And what was done?
What's next, right? Like, I mean, everyone normal, you have to also do your daily job to live and to keep the type of life that you currently facilitate. To keep that moving, you have to work your job. Like, all of that would be trucking in your head. The stress level would be insane.
Done.
Tom went in for the appointment alone. The I don't remember. I think it was a Tuesday he went in. I'm not real sure. I stayed home with the baby. He had a real early appointment, and we weren't getting her up and out quite that early. So he went to the doctor.
Was any diagnosis made?
No, absolutely not. He had called me from the doctor's office and said, he called me at about 10:15 in the morning and said they're sending me to Botsford for a CAT scan. And I said, okay, didn't think anything about it. He had, maybe he knocked his head sometime, and maybe they were looking for some kind of cerebral.
Did he go to Botsford that day?
Yes, he went to Botsford directly from the doctor's office. He drove himself to the hospital. And around noon, he called me, and he was sobbing so hard.
Why?
Because they were admitting him.
For what?
They didn't know.
Did they assign doctors and neurologists to attempt to diagnose him?
Yeah, his doctor there was Dr. Rossman, who was on staff there, and also on staff at the Michigan Institute of Neurological Disorders in Farmington Hills, the Mind Clinic.
And was a diagnosis finally arrived at?
No, not for months.
You're not going to instantly figure out what's even going on with you, right? Like,
he was diagnosed on August 6, 1992, and this was at the end of May.
How long was he in the hospital?
I would say probably 3 or 4 days.
Did they run tests?
They ran a multitude of tests. He had a he had a lumbar puncture that day. He was so frustrated and mad. He did not like being poked and prodded and pinched and things.
Between May and August of 1992, how did his condition continue?
He was having harder time standing up without falling over. Tom, you need to understand, would not give in. He didn't want to give in to anything. We were hoping it was Lyme's disease. I mean, I don't mean to make that seem like it's not bad, but we were hoping that it could have been something that was going to be treatable. They first thought maybe he had a stroke. But since he was outside all the time and he was a hunter and in the elements, he thought we were hoping it was Lyme's disease. They were looking for that.
I just want to make sure that this is his fiance. I just wanted to make sure it wasn't wife, but yeah, this was his fiance, the lady that we'd seen in the early part of this trial in the Dr. Jack Kevorkian when she was actually with him.
They had ruled out cancer. They had ruled out MS.
Did he continue to seek treatment between May and August?
It's a rough one this morning, Joe.
And were any of the diagnoses helpful at all? Were there any working?
Everything was negative. Everything was negative, and but he was starting to lose a little bit more of his agility, his dexterity.
Yeah, were the problems with speech continuing?
Oh, yeah.
Were the problems with using his hands to work continuing?
Very much so, notedly.
Was he able to work during this period of time?
Tom worked. Tom tried to work. Tom was not going to throw in the towel. He wanted to be diagnosed with something that was going to be treatable.
How did it come in August of 1992 that he finally got diagnosed? What happened?
I had taken 3 months off work with the baby. I returned to work on Monday, August 3rd, 1992. Tom was taking care of the baby, and he would drop her off at daycare on his way to work. On Thursday, he had a doctor's appointment at the Mind Clinic, and it was actually just going to be another appointment. They had not told him to bring Heidi. They didn't, it was just they were going to take some more blood, maybe run a couple batteries of tests. Who knew?
What happened?
He went into the Mind Clinic. They asked him to come into a room. He said, I thought
Mind is the Michigan Institute for Neurological Disorders?
Mm-hmm.
Okay.
So he went to the Mind Clinic, and he sat in this room, and he thought, maybe they were going to refer him to another doctor. Maybe they had discovered something that was going to be helpful. So he was feeling a little more positive, because up until now, everything was up in the air.
What happened there?
they sent in a team of 6 doctors that came in and told him that he had amyotrophic lateral sclerosis, better known as Lou Gehrig's disease, and that it was a terminal disease.
Or when did you find out that he had been diagnosed?
He called me, he left the clinic, and he drove home, and he called me at work, and he said, I said, oh, how'd it go today? He said, I'll tell you when you come home, and his voice was very, very weak. It was despondent. He wasn't crying. He was just not there. And I said, well, come up to work and we'll have lunch together. And no, I want to wait till you get home. And I said, no, come up to work. If you're not, I will have somebody drive me home, and I want to talk to you about it. So he came up to work, and I saw him pull up in the parking lot. And when I got to the car door, he had his head on the steering wheel, and he was sobbing. And I said, Tom, what did they tell you? And he told me, and I fell right on my butt. I fell right down on the ground. I couldn't believe what he had just told me. I couldn't believe. When he first said it, amyotrophic lateral sclerosis, I thought, sclerosis, not good. Then I thought, what is that? And he said, it's Lou Gehrig's disease. And then I understood what it was, and I panicked, and my legs gave out from underneath me.
What happened then in terms of his physical condition? Did they offer any hope of treatment?
Did they offer hope? God, let me think. I don't believe that they ever led us on to hope. I believe Tom and I are the people that hoped, and we did pray.
How did his condition continue after that?
His physical condition began to deteriorate. Tom was getting tired. Tom would go outside on a summer day and get chilled to the bone.
Did he have any weight loss?
Yeah, he did, but he ate a lot. They put him on steroids at first, and that increases appetite. And I would maybe sometimes make 3 dinners.
What could you?
But his mental condition is what I wanted to. I mean, his mental condition was.
That's what I wanted to ask you about. How was he taking it at that time?
He was not taking it well.
What do you mean?
He cried all the time. He cried all the time.
Was he having a difficult time accepting that his life would end soon?
I don't think that Tom worried, I don't know the right word to say, about his life ending soon. I think he was scared about what was going to happen to him between now and then. He was scared out of his mind.
To your knowledge, did he have an understanding of the way the disease would progress and the way it would be fatal?
He had a knowledge. Tom was a very, very intelligent person, probably one of the most intelligent people I've ever met in my life. He knew. He can read. We can all read. But when it's actually happening to you in your body, boy, does it take on a different meaning. You know, all of a sudden, these aren't words that you're reading that this is happening to somebody else. Now it's happening to me, and I feel it every day of my life. I'm losing a little bit of my physique every day of my life. And that was a big emotional struggle as well as a physical struggle.
Was he having any difficulty eating at this time?
Not too bad, no. I would say his difficulty eating really enhanced around November of '92.
You've provided me with some pictures I've marked as defendant's proposed exhibits O and P. May I approach the witness, Your Honor? When were these pictures taken? I'm first showing you defendant's proposed exhibit O.
This was the first day that I went back to work on August 3rd. 1992. And
I'm sorry.
I had taken this picture because I was leaving my husband and my baby, and I wanted to stay and didn't want to have to go to work. But
at this point, had Tom been suffering the physical problems but not been diagnosed?
Right. This was 3 days prior to diagnosis.
I'm going to show you what's been marked as plaintiff's proposed exhibit P. When was that taken?
This was in September. This is
Approximately how long after diagnosis?
approximately 3 to 4 weeks.
Okay. And who does that portray?
This is my beautiful daughter and her beautiful father. He was leaving to go to Florida this day to give his family the news of his diagnosis.
Yes, Your Honor, could we approach this?
Is it necessary that are you moving those now or something?
Oh, he was?
Yeah.
Yeah, and I have an objection.
Okay. Those are being moved. There's an objection. I will reserve ruling on that until we had a chance to discuss it further, please.
Thank you, Your Honor. What then happened after diagnosis in the ensuing months of fall and winter and spring of 1992 and 1993?
Tom's physical deterioration was gross.
What do you mean?
It was big. It was immense. His every day was a little bit worse. But see, I lived with Tom every day, and I saw him struggle. I saw his anguish. I watched him fight to stay the Tom Hyde that he has always been his whole life. I didn't actually, I watched his deterioration, yet it was so rapid that I would have a friend that wouldn't see Tom for a couple weeks, or we'd have friends, and then they'd see him 2 weeks later, and they would cry. They'd say, Heidi, you know, and I said, I don't have time to cry here. I can't dwell on that. We're still seeking help. We're looking all over. I'm reading all kinds of articles. I'm going to the library at this time. I took Tom to Florida. We took everybody to Florida at Christmas. We went to Bimini for a couple days. We came home, and when we came home, I had talked to him about going to the Henry Ford Hospital because they do have an ALS center there. We had prior been seeing at the MDA. The MDA deals with 41 different diseases. I wanted to talk to people that knew ALS, and that's all they did.
Did he go to the Henry Ford Hospital?
Yes, he did.
When?
I believe it was after the New Year. It must have been shortly after the New Year in 93, because we had come back from Florida, and he said, Heidi, I'm gonna let you do this. I'll go, but honey, I don't want to be poked and prodded too much, and don't let him do too much to me. When you see me not being able to handle this, just tell him to back off.
What about Tom didn't want to be poked or prodded or had those types of things done to him?
I think if we all thought about it, none of us would want to be treated that way. He was a guinea pig. He was young with Lou Gehrig's disease. Lou Gehrig's disease usually strikes men after 40. It's very rare in women, but it usually...
Excuse me, please, Mr. Mayor. I know that you want to get some things out, but see, the witness is talking of things, I think that she is not competent to testify to. I don't know if she's an authority on when this disease strikes and those kind of things. Let's try to ask questions, that are more pointed towards something, okay? Proceed.
You don't think this is pointed towards something? You don't think the jury's watching this and feeling every fucking aspect of this?
Was Tom aware of the implications of the disease striking at a young age as opposed to an old age? Had that been explained to you by the doctors?
Yes, it was explained to us by doctors.
Ridiculous. What was the implications of the disease striking Tom at a young age rather than an age over 40, according to the doctors?
They felt that Dr. Newman, Dan Newman at Henry Ford told me this himself, that he that usually when the disease strikes patients younger, the disease moves more rapidly.
After you came back in the winter of 1993, what was Tom's condition then? Before?
Very hard to understand. I could understand him, but people would look to me like, what did he say? His speech was very labored and very, very slurred.
Did he enter the Henry Ford Hospital clinic?
He entered the clinic. We were an outpatient clinic. I think we went every 4 weeks, or 3 weeks.
Did they prescribe any medication?
They prescribed baclofen. Leorazol is the generic name, or the generic name of it.
Besides the physical deterioration, was Tom experiencing discomfort in any way, such as the muscle spasms, difficulty swallowing, or the like?
Tom's muscle spasms caused him a great deal of pain. He would get them in his mouth. And Tom was such a strong physical man that it would bring tears to his eyes, and I knew that the pain he was feeling was immense.
Were any of the medications, Leorazol or Valium, effective in eliminating the pain?
No, not at all. I gave him his doses every day myself. I administered all his medication. His Valium was basically given to him to help him rest. Tom had terrible bouts of anxiety, and he wouldn't be able to sleep at night. He was afraid.
Of what?
He was afraid of the next day. He told me that he would lay in bed, and he was afraid that tomorrow he wasn't going to be able to walk. Tomorrow he wasn't going to be able to hold Carmen.
When did he begin having difficulty swallowing and choking?
Around November. November. And
How did that manifest itself?
well, that turned into real scenes. I mean, Tom would choke so bad that he would fall down on the floor because he couldn't breathe. Something would lodge, and he couldn't cough hard enough. His diaphragm now is being affected by the ALS, and he didn't have the ability to cough up anything. So, and again, I would try to approach him, let me help you, and he would say no. When he felt real claustrophobic when people were around him, when he was in these panic attacks, the last thing he wanted was people around him. 3 times I administered Heimlich to him to remove something that was lodged.
Were these frightening to him?
These were frightening to him, they were frightening to me, and they were frightening to Carmen.
Did he continue to grow worse during the spring of 1993?
Rapidly. The longer Tom had Lou Gehrig's disease, the faster the progression was.
Did there come a time in the spring of 1993 that he entered Ford Hospital?
Yes, it was in May. It was on May, I think he went in on the May, it was before Carmen's first birthday. It was maybe like the first week of May. It was before her first birthday, I know that for sure.
Why did he enter the hospital?
Well, his brother Sean was here helping as much as he could.
What type of care did Tom need at this point in terms of just getting around and doing things in the house?
Well, Tom, you'd have to know, Tom tried so hard to do everything that he could.
Could he walk?
He was a walker.
When did he begin using a walker?
After we got back from Florida. I had it, though. It was a piece of equipment that sat in a corner for a long time, and when I had asked the MDA to send somebody to send one out, he was mad at me and don't get that. And I said, hey,
why didn't he want a walker?
He did not. It was an admission. It was an admission to him that the disease was winning, and he did not want to ever admit that. It sat in a corner for a long time, and I don't think he really started using a walker until well into January, when he finally decided that his shillelagh that he used to help him walk was not helping as much as it used to.
Could he dress himself?
At that time, probably till the end of, yeah, Tom dressed himself for quite some time, slowly.
Did there come a time when he could no longer dress himself?
Oh, yes.
When was that?
I would say the end of May, probably all of May of '93.
Were his ability to go to the bathroom impaired?
Yes, as well when his hand dexterity started, his arms, when he couldn't pull his pants up anymore and things like that.
Why did he enter the hospital in May?
Well, I had come home from work one day and Sean was there and they were very quiet. And Tom decides to tell me that he had some episode this afternoon where he had coughed up some phlegm and it lodged and he couldn't get it up out of his breathing passage. Sean thought he was choking on something and he got on top of him. And Tom was trying to, get off him. He couldn't, his lungs weren't moving and it was a terrible episode. And I said, did you call a doctor? And Sean said, no. And I said, his doctors need to know about this.
When they found out, what did they do?
They admitted him.
For what?
For tests, mostly, just to begin with. He was there on, I think he was there on the 4th of May was when we admitted him. And then he was there the 5th. He called me and said, come and take me out of here. Nobody's talking to me. They think I can't talk. They think I'm a retard.
I'm going to show you what's
what he said.
Marked as defendant's proposed Exhibit L. What is that?
This is a communication that Tom had written to the nurse, a nurse that finally he found that was willing to communicate with him.
Why did he need to write notes to communicate?
Because sometimes people didn't take time to listen to Tom. They listened faster than he could speak.
Did he speak in the same type of mumbled tones that we heard on the tape? Or
Not quite that bad. But he's trying to communicate with these people, and he was really having a hard time.
Did he write this?
Oh yeah.
Has this been your possession since that time?
Yeah, he was.
May 5th, 1993.
I wrote that because I wanted to keep it for Carmen.
Was this written on May 5th, 1993 by Tom?
Yes, it was. It was that day.
Why did you want to keep that for Carmen?
Because Carmen's never going to know her dad. She's never going to know her dad. He loved her so much.
Any objections? No.
And I wanted to keep as much as I could that came directly from him for her so that she has some kind of connection with him.
I move for admission of defendant's Exhibit L.
Mr. Kennedy, your response to that?
No objection.
That's it.
What did Tom write to the nurse on that day?
He writes washcloth, and he says 2 milks or a shake, and then he says, I like milk. Thank you. You are the only person that has taken time to communicate since I've been here. I don't know how long I'll be here, but I need to bathe. And on the reverse side, she had written some, write down what you want the doctor to know. And he says, the nasal spray does nothing to relieve the extreme sinus pressure or the pressure in my right ear.
What problem? Could he bathe himself at this point?
Oh, absolutely not.
Would he
I was bathing him then.
When he got out of the hospital, what happened next?
Well, before we left the hospital, we had talked to all the specialists that had tested him there when we were there. We had talked to the pulmonary specialist, is that lung? he took Tom and I into a room. Actually, he caught us on the way out. He was just coming up when we were leaving. Tom did not want to stay in the hospital. I had to take him. We went into a private room with this doctor, and he told us that what was happening to Tom was that the ALS was beginning to affect the muscles surrounding his lungs.
Did he leave the hospital then?
We left the hospital that day with recommendation for hospice.
What was your understanding of what hospice was?
It meant that Tom was going to die. And they couldn't do anything for him. There was nothing more that the hospital could do or the doctors could do. Or it was just to have somebody come and watch Tom, and that's how I looked at it.
Did Tom begin making preparations to pass away?
Tom didn't want hospice.
Why?
Tom was so proud. He was a very proud man, and he did not want people to come in and take care of him. It was enough that he was letting me do what I was doing.
Did you take him home and begin to take care of him full time?
Shortly after, I had called his family, and I said, somebody's got to come and help me, because I still had to work. We were relying on my income and what little Social Security Tom was receiving. And I couldn't quit my job and take care of him. As much as I wanted to, I couldn't do that.
Did somebody else come and help you take care of him?
Sean came up in March. And during the time between January and March, Tom was just happy to, because I would leave him alone during the day for a little bit. You know, I'd have a friend come over at lunchtime and kind of like fake she was stopping by or something, you know. I had different people that would just come and check on him, and I think he kind of knew what I was doing. But I still needed somebody to come and just make sure that he hadn't fallen and hurting himself.
There's been discussion by his brother Sean that after May of 1993, he and Tom went to Florida. When was that?
That was the first weekend in June. It was the first Saturday in June.
Why did Tom go to Florida?
He wanted Randy's morphine.
Who is Randy?
Randy is Tom's mother's husband.
Why did he want the morphine?
He wanted to be out of pain and out of suffering.
Couldn't he get the morphine here? I mean, from the doctors?
No, absolutely not. Tom had asked, but no, he asked before they recommended hospice. His muscle cramps were, I could feel them almost. I mean, this is how great the pain was.
Did you receive a letter from Tom from Florida approximately the same time that Tom wrote the letter to Dr. Kevorkian in June of 1993, which is Defendant's Exhibit H?
It was in June, yeah. I think my letter was a little bit before doctors.
I'll show you what's been marked as Defendant's Proposed Exhibit N, I believe. Is that a letter you received from Tom from Florida?
Yes, it is.
Is that his signature at the bottom of the page?
Yeah.
Did I see it? Were you aware during the time that Tom was in Florida that he was either going to write or did write to Dr. Kevorkian?
Yes, I was aware. I obtained your address for him.
How and when did you do that?
How did I do it?
Yes, and when?
I found you in the phone book. And when did I do that? Tom and I talked on the phone every day for 5 times a day, probably. I had, it was probably around the 15th or the middle of June, towards the end of June. Maybe I'm thinking like the 17th or something.
Was that
I called.
Okay.
I called and gave him the address. over the phone.
Were you, what were your feelings when you learned that Tom wanted you and you actually did attempt to facilitate or help him make contact with Dr. Kevorkian?
I wanted to do at that time anything that I could to make Tom happy.
Your Honor, I move for admission of defendant's proposed Exhibit N.
No objection.
Thank you. What did Tom write to you from Florida?
Heidi, I'm really sorry about your back and the pain that it is causing you. Hopefully this will help you to relax and get some rest. What I was saying the other day about the concert wasn't that I didn't want you to go, but that just because you were feeling no pain because of the pills, that didn't mean you were going to damage it more or do more damage to it. You just couldn't feel it. I'm so glad Carmen was feeling better last night. I've been very worried the past few days, so much so that I've been unable to sleep and almost panic-stricken. I love that little girl so much. Please give her hugs and kisses from her daddy. Would you please send me a full prescription of Valium? I need them. I need some peaceful sleep. Would you do this for me? I need to get this to the post office now. I'll write you later this week. We really need to cut down on the phone calls. I love you too and miss you so much and don't want to go on anymore without you girls. But you can't afford a $200 phone bill. You can't even afford half of that. All my love to my girls, Tom, Daddy.
Were you aware that Tom, while he was in Florida, on that same typewriter wrote another letter to Dr. Kevorkian?
Will you ask that question again? I'm sorry.
Were you aware that while Tom was in Florida, he did in fact write to Dr.
Yes, I knew that. I believe I got this letter first, but yeah, oh, certainly, sure. Because we had made arrangements to fly him home. I had made arrangements to fly him home. I believe that he called and said that he was ready to come home, that he had sent some type of correspondence to Dr. Kevorkian.
Did you have an understanding of why he was contacting Dr. Kevorkian?
I don't know if I can't remember. I'm hoping that, I was hoping then that Tom wasn't getting his hopes up about anything other than meeting Jack and counseling with Jack and Tom, and I had talked about that on the phone.
What do you mean about getting his hopes up?
Getting his hopes up of actually being able to meet him, to meet Jack. Tom's always been admirable, or admired Jack Kevorkian. Jack was a renegade in a way that Tom was also, and he respected that. So I think that maybe he was hoping that they could discuss their mutual things, and I didn't know how easy it would be for Tom to obtain any type of meeting with him, and you know, but you know, I tried to be cheery and supportive, and whatever Tom wanted, whatever he wanted.
When Tom got back, what's the next thing that happened in terms of his physical condition? Was he?
It wouldn't be Murder Church if I wasn't muted. Son of a bitch. I was saying lots of stuff. Okay. Well, what I was saying was, thank you very much, Yeller, for the $2.99. I'll give you that one more time. Appreciate the hell out of that. But yeah, it's been a very tough morning so far, but I did want to, I'm still seeing the mutes come through. I know. Classic Murder Church move there with the mute button. I apologize. But yeah, thank you very much, Yella. Appreciate the hell out of that. This one is rough. We still got about, it's about halfway through this, at an hour 25, 45 in. So yeah, a little bit more to go. Again, thank you all so much for being here. Appreciate the hell out of it. We're going to keep moving. I'm going to go in the smoke one more time because I actually need to run upstairs and use the bathroom, but I will be right back. Thank you all so much. Again, if you need to step away during this, I understand. That's why I was in the smoke for so long there for a moment. I needed to recompose myself for a moment. This one is rough, and man, this lady is strong as hell, and it hits you. Everyone in the chat can already see that, but let's keep rolling. I'll be right back.
And changed from when he had left?
Yeah, he was gone for 3 weeks.
What did you observe in the interim, the 3-week time period?
He had noticeably, he had a shirt on when I saw him, and you could just see his you could see how skeletal he had become. His muscle had deteriorated so in 3 weeks that I could see it in his face.
When did you first make contact with Dr. Kevorkian or know that Dr. Kevorkian had received the letter?
Tom came home on June 30th, and that was on a Wednesday, I think. Thursday morning, I was off work now because I had injured my back helping Tom in the shower, so I had a back injury, which meant I was on disability now. So I was with Tom all the time now. He came home on the 30th. We went to bed, and we were in bed on the morning of July 1st, and the phone rang. It was like 8:45 in the morning, and I said, "Who's calling me this early?" And Jack had left a message, and we heard his voice on the machine, and he said, "This is Dr. Kevorkian. I'm responding to a letter from Thomas Hyde, and he left this phone number for me to call. Please give me a call at this number, and you'll hear a tape, and when you identify yourself, I'll pick up and talk." Well, Tom wanted to get out of bed right away and call, and the baby was just getting up and everything. I said, well, let's just wait till the afternoon when we can actually talk to Jack.
What happened next?
We had breakfast, and he's like, the baby's looking tired. I wanted her to go to sleep right away. Well, she takes a nap around noon, so we put her down.
Did you contact Dr. Kevorkian?
Yes, we did.
When?
At about 12:30 in the afternoon. I had one phone, and Tom had another phone.
Was Tom able to talk over the phone?
No. I told Jack who I was, and that I would be representing Tom because I at this time was the only person that could communicate with Tom.
At this point, in late June, we've had testimony from Mr. Thurman regarding the hospice care. When did Tom finally agree to that?
Tom finally agreed to that when I told him that he wasn't going to fly home without it. I said, when you come home, I need help. I can't lift you anymore, honey. I said, we have to at least have somebody come and bathe you. I can dress you, I can feed you, I can do everything else, but I can't do
all those help, all that help.
He didn't actually have to be spoon-fed. No, never. Tom ate by himself, and it was very hard, but he did it. Tom did not give up, ever. Did he give up?
Okay. When did hospice care start? As soon as he got back?
In fact, we met hospice at 3 o'clock in the afternoon. I picked Tom up at 11 at the airport in the morning. And the nurse that comes and interviews, and they sent a social worker also to do a basic interview.
Was this a recognition by Tom of the end coming near, in your opinion?
I'm not quite sure. I think he always thought he was doing it for me, to help me. For me to get help, because even in the interview he was saying she needs help. She does need help taking care of me. I'm getting harder to take care of.
Did hospice care then start?
Yep.
And how often would hospice come?
They came Monday through Friday, anywhere between 9 o'clock in the morning and noon, and they stayed for an hour and a half to 2 hours, and they were there strictly to bathe Tom. In the first week, we had a couple different people until they could find us a caseworker. In fact, Tom was Kelvin's first patient.
Okay. When you spoke to Dr. Kevorkian, what arrangements were then made?
Well, the doctor had, first he wanted to know if we had medical records. That's the first question he asked me. Yes, I said I have a plethora of medical records.
Why did you have Tom's medical records?
Because I obtained everything. I, at a point, was not going to let this disease kill Tom either. I wasn't going to let this take my husband away from me. There was no way on God's green earth that they were going to take him away from me.
When you told Dr. Kevorkian you had the medical records, what happened then?
He said, good, I'd like to arrange a meeting. I asked him, do you want me to send them to you? He says, well, I'd like to arrange a meeting. I'd like to meet Tom. I'd like to meet him. And I said, whenever. And he said, is today okay? And I said, sure, and Tom's always on the line. I never communicated ever with Dr. Kevorkian without Tom there. We had 2 phones. We'd sit across the dining room table from each other. He heard everything, and he also heard me speak. I can communicate with Tom with our eyes, or he could spell things for me. He could write things. I only communicated through Tom. He communicated through me. I'm sorry.
Okay. What happened then?
We made an appointment for that evening. We decided it would be around 7:30 because it was a better time to have the baby in bed. She gets around quite a bit, and I needed to not be distracted because I needed to translate for Tom.
Okay. What day was that?
July 1st,
okay.
1993.
And what happened?
We let the baby skip her afternoon nap so that she would sleep, go to bed early. And we had dinner, and I put her down at 7. I remember walking out into the parking lot with a bag of garbage, and when I was walking back through, I could see Dr. Kevorkian with his signature hat in a car. And Tom was coming down the hallway. Our door of our apartment was open, and I could see him. He was going to the bathroom, and I said, "They're here. He's here." I was so excited.
And did he come in?
Oh, yeah. Oh, did Jack come in?
Yes.
Sure.
And what happened then?
Came in, and we looked at pictures on top of my entertainment center and looked at family photos. And at this time, Tom was still in the bathroom. They hadn't really met Tom, and I looked pretty healthy. They knew they weren't there to see me, but eventually Tom could get, it took him probably about, I'd say 5 minutes to get to the bathroom, and it's maybe for you and I, 10 seconds. Maybe 10 seconds. And it took him 5 minutes. When he finally comes around the corner and into the dining area, and I introduced him to Dr. Kevorkian and Neil and Margot.
How did he get into the dining area? Did he have a...
He had his walker.
Okay.
Tom never used a wheelchair in the house.
Okay.
Never.
Then what happened?
I offered coffee, no coffee. We sat around, we all took places at, well, actually, yeah. Well, I had already given Dr. Kevorkian the medical records. He was already deciphering the medical jargon and things.
And then what happened?
We sat down at the table while Margot was setting the camera up.
And is that when, after Dr. Kevorkian had been reviewing the medical records, is that when the discussion began, or had there been a discussion before that?
We discussed nothing about Tom until after he saw the records. We talked.
I'm sorry, you misunderstood me.
Okay.
The tape that's in evidence, and
yes.
I'm going to play now, Exhibit A. After Dr. Kevorkian reviewed the medical records, but before the tape started, was there any
should be statues made of this lady in this town? Okay, like
between you and Tom and Dr. Kevorkian that you can relate.
Not attributed to to his condition or anything.
And so
Maybe small talk.
when the tape begins is when we begin to see the first counseling session.
Correct.
Tape.
I'm sorry.
What is the reason for playing the tape?
The reason for playing the tape, Your Honor, is that the tape was played, it's in evidence, during the prosecution's case. This now, in the compendium of events, allows the jury to see virtually exactly what happened in the way it happened, in the manner it happened, under the circumstances it happened. And although I've seen the tape, there's things that I see in the tape the 10th time that I didn't see the first time, and I don't. The tape's
well,
only.
You're not the witness, okay? We're not concerned what you saw or didn't see, okay?
Yeah, I seek to put in evidence.
All right.
This is. I don't. It's already in evidence.
All right. Any other?
Yes, Your Honor, under 403, we would object with regards to it being cumulative at this point.
I would agree. I'm not going to allow you to play the tape again for this
Your Honor, it is not cumulative. Cumulative refers to new evidence being put on top of old evidence. It doesn't refer to evidence that's already in evidence being used for the purpose of showing or using it during a witness's testimony. That would be like saying you can't show a witness medical records that are in evidence.
Your record is made, Mr. Feiger. Let's proceed with the next question, please. Okay.
What happened then?
Dude,
after
Feiger
the count
rules. Feiger is amazing. Holy crap, dude. Unbelievable. While I was kind of looking up Feiger here, I saw that he's recovering from a stroke. When Joe Jacqueline was recommending maybe getting someone from this trial on the show, I was looking him up, and he has a website. One of Jeffrey Feiger's best-known clients, Dr. Jack Kevorkian, the man who became known as Dr. Death in the 1990s as a result of helping more than 100 chronically ill patients in their suffering through assisted unaliving, suicide. Yeah, I said it. Feiger successfully defended Kevorkian through 7 murder trials and became nationally known for his tireless pro bono work on behalf of Kevorkian and his cause, citing the right of all Americans to end their suffering if mentally competent. Feiger and Kevorkian kept in touch until his death in 2011, man. Feiger rules.
Counseling session.
We talked about the actual procedure.
Mm-hmm.
I don't really remember, Jeff. It was quite an emotional day. But I do remember we talked about procedure, talked about dates and time, things like that. Jack asked Tom, what's a good day for you? What can we possibly do to help you to alleviate your suffering? What can we do for you?
Tom expressed on the tape that he wanted to be free of this, I think, is to paraphrase. I don't know exactly because I haven't seen the tape recently, but to paraphrase what the tape, what did you understand that to mean?
He wanted to be free of his body. It was his body that was giving up on him, and Tom told me that in some of his crying, things that made him cry was a thought that his body had turned against him.
Did Tom want to die?
Absolutely not. Tom loved life more than anybody else I know on this earth.
Did Tom want to commit suicide?
Absolutely not.
What did Tom want?
He wanted to end the suffering, and the body was just in the way.
Did anyone offer him another way to end the suffering other than the medical procedure by Dr. Kevorkian?
Did anybody offer him
Any other medical doctor give another
alternative? To offer him how to
alternative?
quit suffering? Absolutely not.
Did Tom know that the procedure that was being offered by Dr. Kevorkian, even though it might end his suffering, would hasten his death?
I'm sure he was aware of that. Tom was an intelligent man. Tom was not concerned with that. Tom did not want to suffer anymore. Period. The end. What came after that didn't matter to Tom.
Help us understand how somebody could be in that much pain. You're the person closest to him. To be in that much pain and suffering, to that the prospect of hastening death is more acceptable than continuing the pain.
He was living in hell, Jeff. His life was not worth. I mean, his life had a plethora of worth. He just was having he was struggling with the emotions brought on by the fact that he couldn't even open up his fingers anymore. He couldn't straighten his fingers out. That happened in one day. Did anybody ever tell you that? That was an overnight thing that happened to him. One day he could do it. The next morning he woke up and he said, Heidi, I can't straighten my fingers out. That happened overnight, and that's what happened to Tom. That's what this disease did to him.
After Dr. Kevorkian left, what was continuing to happen for Tom?
That evening, Tom was, he was relieved. He was relieved because somebody had offered him up a little bit of control. Somebody had told him that they may help him to end his suffering. That is something that I couldn't even do, world. And I wanted to do something for him so bad. I did everything else for him. This was what I couldn't do.
Were any plans made at that time with Dr. Kevorkian, or what was the was Tom encouraged to continue to go on?
Tom was continually encouraged to go on.
By who?
By Dr. Kevorkian, by Neil. We all sat around, we looked at his rock climbing pictures, and the pole vaulting, and Jack and Tom even pole vault. I mean, they had so much in common. I was happy that they met. I was extremely happy that they met. We talked, the assurance that everything was going to be okay, just enjoy life.
How did Tom, we've seen pictures of Tom in the tape on July 1st. How did he progress over the next month before August the 4th?
Dramatically. He was a skeleton on the last time that I saw Tom Hyde, he was a skeleton with some skin spray painted on it.
Did he continue to receive hospice care?
Kelvin came in the morning and bathed him.
Kelvin indicated that he had to help him with the bathroom. Is that true?
Yeah, well, yeah. Because I was able to get Tom up and get his shorts on for whatever reason, because we knew Kelvin would come and they'd soon be off. But Tom had pride till the end, and wanted to wear his shorts around the house. And so I'd help him get him up out of bed. And, we slept together, so. And he worried about that because his muscle spasms would be all night long now. Now they're all night long.
What do you mean?
And they would keep me up.
What do you mean?
His whole body would just spasm. And he had no control over it.
In the month after he had counseled first with Dr. Kevorkian, did his mental outlook change at all?
It was, he wasn't struggling anymore within himself. That evening, as I was seeing Margot and Neil and Jack to the door saying goodbye, he had gotten over to his lift chair, and he sat down and he said, "Let's get drunk." And Tom never drank while he was sick. Any little bit of alcohol would weaken his muscles so much that he didn't need that on top of everything else that was happening to him. That was very easy for him to give up, the occasional beer or whatever. But that night we had a couple drinks and we rode around on his electric scooter and out on the sidewalk. We didn't get too far away from the baby, and our sidewalk's right there, outside the door.
What do you mean you rode around in his electric scooter?
I sat on his lap and we took a ride, just up and down the sidewalk.
What's a scooter?
Oh, that was his electrical cart. It's a battery operated, I guess.
Okay. So does that look like a wheelchair?
No, it's. See them in grocery stores, like little scooters.
Why did he use those?
That was a good thing that we got, because that gave him a ton of freedom. As Tom could get the door open with his hand. We didn't smoke in our house. We made that decision when the baby was born, no smoking. This man would go outside in the bitter cold to have a cigarette when he was so dilapidated, you know what I mean? I said, Tom, go in the bathroom and smoke it. And he'd say, no, we don't smoke in our house, that's it. You know, he was so
Did a time come when you decided what day it would be that Dr. Kevorkian would help Tom with his suffering?
Tom made that decision, I did not.
How did Tom, if you know, come up with that decision?
I don't think I know. I know why it was the 4th and not the 3rd.
Why?
Because he wanted to sign a Social Security check.
Were you aware that it was going to be the 4th?
Quite aware of that.
What was Tom like on the 3rd?
Fun. We went out to Proud Lake. We put the cart in the back of the truck.
Help us understand how somebody who understands that would be happy about this.
I don't think anybody can understand except for Tom Hyde. Tom Hyde is not here to tell. I will try to tell you how I felt, what came from him.
Well, I'm going to object to that.
Okay, okay.
Your Honor. Objection, okay. Please proceed to your next question.
Did Tom write you a letter on that final day
On that evening after dinner.
expressing to you his feelings? Did he?
Pretty much, yeah, I'd
I'm
say
going to show
that.
you Exhibit M. Is that the final letter he wrote to you in his handwriting?
Yes, it is.
Proposed Exhibit M. Any objection?
Yes. Objection as to relevance, Your Honor, with regards to his state of mind.
May I just glance at it, please? Pass that up, Frank. What is your reason for offering this, Mr. Feiger? I thought we had some...
Shows a state of mind.
It doesn't show a state of mind about the pending circumstance.
That's right.
That's what you were asking her about, how he felt happy because he was going to face something the next day.
That's right.
How does it show that?
It shows that he's happy about it. It says he's happy about it. And he doesn't intend to commit suicide. He intends to be relieved from suffering. And the prosecutor has
Wait a minute, that letter doesn't say that.
I agree.
Well,
partly.
he says it doesn't. He's my opponent.
I read it, okay? I would not admit that for that reason. All right.
I'd like to make a separate record on this.
You'll get a chance to make your separate record on that later, okay?
Did Tom indicate to you that he was happy for his
Certainly
decision?
did.
Objection, Your Honor.
Sustain the objection.
Your Honor, the prosecutor in this case is required to prove not only the elements of the crime, but also that Thomas Hyde intended to...
Objection.
Your
okay.
Honor, I need to make a record
Well,
on
make
this.
a record then. Don't give me a speech, okay? Make your record. What do you want to say?
The prosecutor is required to prove beyond all the other things that Thomas Hyde intended to commit suicide, which he never intended to do. I'm entitled and I'm seeking to put in proofs regarding the failure and the lack of any proof by the prosecutor and affirmative proofs here that Thomas Hyde did not intend to commit suicide, but intended to end his suffering.
Well, whether he was happy or not doesn't necessarily answer that concern, Mr. Feiger. That's the objection, and that's why I sustained it. Okay, now go on.
Well, Your Honor, just for the
Mr.
record...
Feiger, you made your record, okay? Any court of review looking at this will recognize you made your record. Now, let's proceed.
Did Tom want to commit suicide?
Nope.
Was he committing suicide?
Objection, that's for the jury to determine, Your Honor.
Well, she can make her own observation.
Sustain the objection on that, please. Proceed to the next question.
What did Tom want?
Tom wanted to end his suffering. He wanted to not live every day in agonizing pain. muscle spasms, deterioration, loss of dexterity, loss of the fact that he couldn't hold his child anymore. Watching her grow, watching himself deteriorate was an emotional trauma that Tom did not want to experience anymore.
Were you there the morning of August the 4th, 1993?
I sure was.
Tell us what you and Tom did that morning.
Well,
just before we do that, Defendant's Exhibit D states, and it was written on the tape, I feel like the main character in the book Johnny Got His Gun, must read. What does that mean? Did you know what that meant?
Sure I did. Tom had referred to that book quite a few times in his illness to friends to communicate a little bit, to help them try to understand a little bit of how he was feeling being stricken with this disease. This was a good way for him to let them know exactly how terrible this struggle was, how terrible this suffering was.
Prosecutor has asked many questions about the consent form that was signed on the tape, that Tom signed, I believe, and you countersigned, am I not correct? Exhibit 9.
That is Tom's signature, that is my signature.
When he requests that my life of intolerable and interminable pain and suffering end, what was his life? Was he suffering intolerant and interminable pain?
Yes.
Were any of the other medications in any way, shape, or form helping him with that?
No, not at all. They were they were not a miracle drug. They were nothing. They did nothing but make Tom groggy, make Tom weak, make it a little less easier for him to actually light his cigarette. You could see the difference before we'd give him Liorazol, which I gave with breakfast. If he would have a cigarette before, he could light his after his Liorazol would make him weak, and I'd have to light his cigarettes for him.
What did you folks do that morning?
Us folks got up. I got up about 4:45. So I could shower and start coffee. Tom loved coffee. I wanted to make sure that he had as much coffee as he wanted. Tom wanted to be up and out of bed by 5:30. And I do mean up and out of bed, that means dressed, because it did take maybe about 10 or 15 minutes every day for me to do that. I would have to swing his legs outside of the bed, actually bend them so that his feet would be parallel with the ground before I could lift him up. To put each hand on the walker handle, I would have to take his fingers and bend them around the walker handle. I'm talking about a 30-year-old man. I have to control I would have to control his fingers that much. Then I would begin to dress him. And he wanted to wear my sweatpants and my shirt that day. So that, because I couldn't be there, and he wanted me to be there as much as he could. As much as we could. So we thought, well, you can wear my clothes and I will be there.
Why couldn't you be there?
Because there are certain people that said that there are certain people called the government or something that said that I could not attend this end of the suffering day.
So you mean if you were there, you might be sitting over where Dr. Kevorkian is?
I've been told that.
Yeah. Who came and when did they come? Okay.
Neil, Nickel, and Margot Janice.
And what happened then?
Well, Tom was sitting in his chair. Well, he had a special chair. I mean, he had a regular chair they sat at the table, but it was his place at the table, and he was sitting there. And he had just, when I opened the door and Margot and Neil came in, Tom was like looking at me like with his head, get me up. Get me up. And I said, well, wait a minute. They wanted me, he wanted to get in he wanted his walker, and I said, no, I'm gonna put you in the wheelchair and push you out.
Was this Tom's decision alone?
I can't think of any, of course it was Tom's decision.
Did anybody attempt in any way, shape, or form to coerce Tom, including yourself?
Never.
Dr. Kevorkian?
Never.
Why did Tom, if you know, feel that he had the right to decide how much suffering he had to undergo?
It was his life. Who else has the decision? Who else is going to make that decision for you? How long you are going to suffer?
Well, at that point, couldn't Tom have gone out? I know you say his hands he couldn't move them, but couldn't he go out and get a gun to do it himself?
Tom couldn't even lift a gun.
Couldn't he have gone out without somebody's help into the garage and run a hose from the car into the car and turned it on himself without anybody's help?
Tom didn't own a car.
Couldn't he have wheeled himself up to the second floor of a building and jumped off?
No, we lived in a handicapped apartment on the ground floor. Only access to any upper floor would be stairways, and stairways were off limits for Tom.
Couldn't he have wheeled himself in his scooter in front of a car and had somebody else kill him by accident?
No, Tom didn't want to commit suicide.
Why didn't you shoot Tom and then kill yourself?
Because I loved Tom. I loved Tom, and I would never, ever shoot him. Ever. Besides, I have a daughter who needs me very much, who needs her daddy too. But he's not here, so I'm mommy and daddy. And that is the foremost reason for my living right now.
Was Tom ready to end his suffering at that time?
You bet.
Was there any hesitation?
None at all. None at all. I would think that he would have been more anxious. He didn't want to wake up another day and have his daughter see him fall on the floor and knock the wind out of himself. Tom's anxiety and these things, you have to understand, were not only affecting Tom, these outward things, they were affecting Carmen.
Did Tom understand that if Mr. Kenny is right, that Tom was conspiring to commit a crime by ending his own life?
Your Honor, that's argumentative.
Stand, please. No, sustain the objection. Come on, let's go on.
It wasn't argumentative, but why was Margot there?
Because I was alone. I should have been with Tom, but I wasn't. I had to be alone. And I was glad for her support to be there with me.
Did Tom leave then?
Yes, I helped him into his wheelchair, and I pushed him outside, pushed him up the walk and to the parking lot. And I helped him up, and I put his hands on the car door to bend his fingers around again to so he could hold on while I moved the chair away. And I hugged him, and I never wanted to let him go.
Did you love him?
I still do.
Did you ever feel that Dr. Kevorkian had ever done him any harm?
Dr. Kevorkian was the only person that was willing to help him. He was the only person that could help him. We had been to so many doctors and everything, and I dragged Tom all over town to go see people to try to help him to quit suffering. Nobody was helping us. And I couldn't help him either.
No further question.
Mr. Kenny?
Do you need a moment, Ms. Fernandez?
Yes, I do.
Okay. Just let me know when you're ready.
I'm ready, Mr. Kenny.
Ms. Fernandez, you indicated that when you got to the parking lot, you got, or you helped Mr. Hyde up out of the chair. You hugged him. You indicated that you didn't want to let go, correct? And that was because at that time, you knew you weren't going to see him again alive. Isn't that true?
Nope, that's not true.
Are you telling us that at the time that Mr. Hyde got into the vehicle wearing your clothes, that you were expecting him back at the apartment later that day?
Expecting?
Yeah.
I don't know how I felt right then. I don't know if I could say expecting. Tom's still alive to me. Tom's still here. I see him in my dreams. So Tom, it wasn't the last time I saw Tom. I never thought it was going to be the last time I was going to see him.
My question for
I
you...
knew that his suffering was going to be over.
My question for you, Ms. Fernandez, is at the time that you parted in the parking lot by your apartment building, as the vehicle pulled away,
I didn't see the vehicle pull away.
were you expecting to see Thomas Hyde alive later that day?
You've already asked me that question, and I told you I don't know what I expected that day.
Had you made plans for him to be home for dinner?
Let's see. Did I make plans for him to be home for dinner?
What a question.
Did I take out some pork chops and thaw them out? No, I didn't do that. I wasn't really quite sure, Mr. Kenny. That was a very emotional day for me as a result of Tom's suffering being ended. Pardon me if I don't have total recall.
By the way, with regards to the medication that Mr. Hyde was taking for the muscle spasms, the Liorosol and the Valium, did there ever come a time when you or Mr. Hyde ever requested from the treating doctors anything a little stronger or something that might be more effective than what had been prescribed?
Yes, sir, Mr. Kenny, we did.
And was anything ever prescribed for him?
No, sir, Mr. Kenny, it wasn't.
And were you given a reason why no other medication would be given to him other than the Liorosol and the Valium?
That would be 5 milligram Valium. I would say that We never really got a reason, no. Just that the medication that they prescribed was good, was fine, and I said, it's not. Tom is trying to tell me to call you every day to tell you that he's in too much pain. He needs something for the pain. They told him to take more Leorisol, double up on his Leorisol, made Tom a rag, made him a virtual rag. He couldn't even move. And as far as his Valium went, I had to give him 2 Valiums. And I said if I could get 10 milligram Valium, I'd only have to put 1 pill down his throat, which he was having trouble swallowing 2 pills. Could we put it into 1 pill? No, Ms. Fernandez, that will not happen.
Ms. Fernandez, you told us that you felt you could not be there with Mr. Hyde on the morning of August the 4th.
I was with Tom on the morning of August 4th.
You couldn't be with him when he was leaving your apartment.
I suppose
to go
I
with
could
Mr.
have.
Nickel.
Suppose I could have.
You chose not to, correct?
Tom told me not to do that.
Anyone else tell you to not to do that? Nothing further.
Mr. Feiger?
Nothing.
Thank you, Ms. Fernandez. You may stand down. Mr. Feiger, you have another witness to call?
Other than you ruling on these exhibits O and P, the defense rests.
Okay. I'll hold off on those for a minute, please. Is there any rebuttal by the prosecution?
Yes, Your Honor.
Okay. Let's proceed.
Oh, okay. Mr. Rose?
How long is this next one? Holy crap.
Good morning, sir. Would you please...
As they're taking her out. Whoa, okay. All right, 11:39. This one's 18 minutes. I'm going to keep on trucking here, really because I need to regain my own composure.
Tell the jury your full name, please.
My name is Edward Rose.
And Mr. Rose, what do you do?
I'm the Director of News Operations for WJBK-TV here in Detroit.
And what does that entail, sir?
I am responsible for the technical operations of the news department, everything from the photographers to the editors to the tape archives, things like that.
And what are tape archives?
Tape archives, everything that we broadcast on the air is saved for a period of time for purposes if we have to go back. If we're covering a continuing story or something, we can go back into these archives and pull out tape and use it again.
So like if we get depressed about watching the Tigers right now, we can have you pull up something from happier times?
Yes, that's correct.
Now, did you receive a subpoena from the prosecutor's office, sir, regarding items from your tape archives relating to news coverage by Channel 2 on August 4th, 1993?
Yes, I did.
And did that relate, sir, to a press conference held by Dr. Kevorkian and Mr. Feiger?
Yes, it did.
And pursuant to that subpoena, did you go and look in your archives for any tape relating to any press conference comments made by Dr. Kevorkian and or Mr. Feiger?
Yes, I did.
And that was relating to the death of Thomas Hyde?
Yes, sir.
Did you in fact find it?
Yes, I found several tapes.
And can you tell us, please, did you, pursuant to the subpoena, transfer tape that was from your archives into another cassette tape for use in court?
Well, actually, the subpoena asked that someone from the prosecutor's office come over and view the tape. So I showed him the actual show tape from that day. It was a tape that was a recording of the broadcast of August 4th of our 4 o'clock newscast, which we viewed, and after watching it, it was determined that he would like a portion of that tape transferred to that videotape
And
for
was
you.
that done, sir?
Yes, sir.
Showing you what has marked as people's exhibit number 10. Is that the tape that was made?
This is that tape.
Could you tell the jury, please, Mr. Rose, what you did in your job capacity in order to make that particular tape?
I took the tape of the broadcast of that day. We tape every broadcast that we carry, we make a copy of. I took a copy of that down to our tape room, along with this tape, and asked them, it was queued up to a certain portion of that tape, and asked them to make a copy of that tape directly onto this tape.
And was that done, sir?
Yes.
Was there any portion of the 4 o'clock news from August 4th, 1993 that you eliminated in making the tape that you have in your hand right now?
I eliminated the first 20 minutes of the show and the last 20 minutes or so.
Okay, and why was that, sir?
Because it was determined that this portion of the tape concerning Dr. Kevorkian and Thomas Hyde is what the prosecutor wanted.
Okay. Portions you did not put on the tape, did they have reference to the Thomas Hyde incident, sir?
At the very beginning of the 4 o'clock show, we said this had happened, and that as soon as this news conference was going to happen, we were going to switch to it live.
All right. And when you say switch to it live, you mean what, sir?
When the news conference began, we went on location to Mr. Feiger's office, outside Mr. Feiger's office, where we had a reporter standing by and a photographer, and we went live to them to carry it as it happened.
Okay. And does the cassette that you have in your hand right now, People's Proposed Exhibit number 10, is that in fact a copy of that 4 o'clock live newscast coverage that your channel made back on August 4th, 1993?
Yes, it is.
I move for its admission, Your Honor.
I want to examine the witness.
Go ahead.
Mr. Rose, you remember me calling you before the trial started asking for all the copies of any tapes you have of anything on the Hyde case?
Yes, sir.
And do you remember you said you were looking for everything, and I think you gave me a tape that looks almost exactly like that one, doesn't it?
Yes,
Here,
sir.
You can hold it right there. And do you remember you said to me, there's one I don't have, Mr. Feiger, that's the 4 o'clock broadcast, and I can't find it. Do you remember you said that?
That's correct. It was a Saturday.
Right.
And the people who were at the station at that time could not find it.
Right. But I guess you found it for the prosecutor afterwards, right?
And what I told you on the phone was, you told me what you were looking for.
Right.
And I told you I had found what you told me you were looking for. And you said fine, and I said, if you need anything else on Monday, to please call me, because I will be looking for the tape.
So you did find it, but
I found the tape on Monday.
Now, the tape shows not a whole broadcast of a press conference at my office, does it?
That's correct. It does not.
In fact, it shows only me answering a question, one question, and you can't even hear what the question is. Isn't that right?
I think you can hear what the question is, and we showed the first, from the very beginning till where we left the air.
Right. You left the air after I answered one question, right?
I believe it was one question.
Now, to your knowledge, the press conference with me answering questions continued a long time after you left the air, right?
I don't know how long. I know it continued.
Did you have any tape of me answering the questions that at that time since this event had just happened on August the 4th, and this was the afternoon of August the 4th, and I had just been retained to represent Dr. Kevorkian.
He's testifying now. This is an authentication.
I'm sure you are aware of what proper procedure is.
This is cross-examination, Your Honor.
No, this is not cross-examination. What this is a voir dire on the admissibility of the tape. You will get your chance to do that when the prosecution finish with the witness. This is not cross-examination right now. This is your voir dire on the admissibility of the tape.
Oh, I thought he was done with the, he can't,
Mr. Franklin, you got up and you said, I have some questions. He moved for the admissibility of the tape. You said you had some questions about
I'm sorry, Your Honor. I thought he's moving for the admissibility of the tape, and then after he puts in the tape, I get to cross-examine Mr. Rhodes?
He's not finished with the witness. The whole issue right now is whether or not the tape is to be admitted.
Okay, based upon your ruling, we've made a record on that, so I don't have any more voir dire on that.
All right, great. You'll get a chance to cross-examine him then. Okay. All right, Mr. Kenny.
Ring the bell!
All right, move for the admission.
Well, I rule it's been ruled on, and except for all the matter of record, then you may go ahead and play it.
Okay.
Get in the video. I'm recovering over here.
As we told you at the beginning of this newscast, Dr. Jack Kevorkian has assisted in his 17th suicide, and we go live now to his attorney's office in Southfield.
I'll be glad to answer a few questions, and I'm going to turn it over to Dr.
You're
Kevorkian.
just beginning to speak. He's introducing Dr. Kevorkian. Let's listen to him.
I decided to do this conference not for publicity. I don't care for publicity. I don't need it, and neither does what I'm working on need publicity. I did it to clarify the situation. I assisted Thomas Hyde in a merciful suicide. There's no doubt about that. I stated emphatically. I will always do so when a patient needs it because I'm a physician. I'm a pathologist, but also a physician. My main criticism in this is to the medical profession. Not doctors themselves, many support this, but the politicians who run the profession, who call themselves physicians. They're politicians first, businessmen second, and physicians third. They ought to be ashamed of themselves to have human beings like Thomas Hyde suffer immensely, unable to move any muscle, cannot speak, cannot swallow, have pain in addition to all that, and they turn their heads because we've got to discuss this a little more. Now they have a meeting planned in a couple of days with ethicists, lawyers, politicians, philosophers, legislators to talk about what?
They're playing it. They're playing this again, Sarah, for some reason. 499 coming from Sato to globalism, passing the plate and the bowl. Damn. Give me the loot. Give me the loot. Ew, and I got one special just for Sato to globalism.
This is gun country.
This is indeed gun country. Thank you very much. Appreciate it. Yeah, they did play this earlier, I'm pretty sure.
The world knows there's a need for this. The talk is senseless, pointless. There's nothing new to be said about this. So I blame first and foremost the medical, organized medicine. They are the culprits in this because all they need say is, this is a needed medical service. This is how we will do it. We don't need any law to tell us how to do this, like we don't need any law to tell us how to do a heart transplant or a gallbladder operation. This is our business. We know it. And it has nothing to do with religion, philosophy, or ethics. It has to do with medical service. And only physicians can do that. Nobody else. Nurses, physicians, paramedical people, physician assistants. They will do the deciding when the patient needs the service. The patient is the ultimate decision, autonomy. So you have two things involved in this, not law, not philosophy, not ethics. You have medicine and personal autonomy, and that's all that's needed. You don't need press conferences, you don't need laws, you don't need any kind of persecution or prosecution or arrests or fingerprinting. You don't need any of that. A civilized society would face it squarely and do it right. So my criticism is first to medicine, almost equally harsh against the authorities who run the governments, who try to dictate to the people based on their own personal prejudices and override personal autonomy. These are the ones who are to blame for all this controversy. And I state emphatically, any real physician would help the patient who needs it despite any other consideration. But as Hippocrates said in the old days, physicians, like in those days, today too, physicians are many in name but few in reality. So my challenge is to the medical profession to stop talking, stop all this jostling, get down to business, declare that it's a medical service, then it's covered by law, like all medical service, and then you sit down and lay down the guidelines and the rules how you'll operate, and you'll change them every week as you learn more and more. No law can do that. I appreciate this opportunity to explain my position and exactly what the situation is. Thank you. I have one other announcement. Mrs. Hyde has requested...
Oh, that is the same. Never mind. That was totally the same. Mic fucking drop, but I think that was the same speech. I'm not sure why they're playing this again, Sarah.
And I support it. There is nothing she can say to anybody. So she requests that she not be bothered in any way with questions or any kind of request for interviews. And I told her that I promised her that I would make that announcement, and I agree with her. There's nothing she can add to this story, so please be considerate of her period of grief. Thank you.
I anticipate some of your questions. I'd like Dr. Kevorkian also.
He was diagnosed in August of last year. There. Thank you.
I don't think we saw this part.
Well, you all know what ALS is, amyotrophic lateral.
Because remember, I think they pulled back to the lady that was
sclerosis. It's a disease of the spinal columns. Lateral meaning the side parts of the spinal cord. Sclerosis meaning scarring. It's a scarring, a specific scarring of the nervous system. Amyotrophic means the muscles wither away. Mr. Hyde's disease was unusual. He was diagnosed in August of last year, and he progressed to terminal of August of this year. He could not speak. It was unintelligible. He could make noises, but he couldn't. You had to be very careful and listen closely. Only those closest to him could understand him. He had difficulty in swallowing and in breathing, especially when he's lying on his back. Mrs. Hyde had to turn him over on his side constantly so he could breathe easier. He couldn't move at all. All he could move was a little on the left hand, just a short movement like this, and he couldn't straighten his fingers out in that hand like this. Just absolutely impossible. He couldn't raise, when I saw him a month and a half ago, he couldn't raise either arm more than this level. Now this one was completely paralyzed, and he couldn't walk, he couldn't stand up. Very difficult. With a walker, he would walk about a yard in about 5 minutes, I think. He was terminal. People criticize and say, well, that's not cancer. They think only cancer is terminal. Any disease or affliction that limits life from its natural ending is terminal. Alzheimer's is terminal, ALS is terminal, multiple sclerosis is terminal, and even strokes are terminal. So that criticism is not valid. But he had a very severe case, very rapidly progressing, and in 1 year went from diagnosis to almost terminal.
Thank you. I'll be glad to answer any questions. Again, Dr. Kevorkian isn't going to be answering any, and Heidi Fernandez isn't. Yes.
Jeffrey, what does Dr. Kevorkian mean when he says he assisted in the suicide? Can you or he explain more specifically?
You have all been covering this story now. Heidi, you can come in here. For now over 3 years. I think it's significant, and I think it's apropos that Thomas Hyde died in a beautiful park setting in Belle Isle in Dr. Kevorkian's what's been described as a rusty old white van, but actually is truly a really kind of nice van, and there's nothing ignominious about that.
I don't think you missed anything.
Dr. Kevorkian has been utilizing his method of assisted suicide with regard to the use of carbon monoxide for quite some time, and you're all familiar with that. And that is exactly the method that was used in this case. And again, as Dr. Kevorkian's press release in
morning, as Dr. Kevorkian's involvement in the 17th, diagnosed with Lou Gehrig's disease, committed suicide this morning, as Dr. Kevorkian said, with his assistance. We'll continue to follow the story, and we'll have more from this news conference on Eyewitness News at 6. Reporting live from Southfield, Jennifer Howe, TV2 First News.
Okay, thanks, Jennifer, for that live report. And, of course, Dr. Jack Kevorkian saying today that he indeed assisted in the suicide of Thomas Hyde. That is possibly a direct challenge to the state law now in the books. We'll have much more as First News continues. Stay with us.
I have nothing further, Your Honor. Thank you.
Oh, no, Mr. Frager.
Thank you. Mr. Rose, you didn't cover the rest of the 30 or 40 minutes of the press conference, did you?
I'm going to object, Your Honor. The question assumes facts, not in evidence. says
this is cross.
Hold on a minute, okay, all right. I guess the objection has to do with the length. Can you maybe establish if he knows what the length of time was, whatever it was? I think the objection has to do with what amount of time might have been involved.
Do you know how long the press conference continued?
No, I don't.
Do you know how, if I said during the press conference that I hadn't yet conducted an investigation?
Do I know that? No.
Yeah.
No, I don't.
Okay. When did I do my investigation?
objection, Your Honor. How would he know?
Okay, I'm sorry. Do you know if I did an investigation before I came to this trial about where Thomas Hyde died?
I don't know that.
When did you learn, when did the prosecutor subpoena you?
He subpoenaed me Monday or Tuesday.
Of this week?
This week, yes.
Of this week, okay. Before that time, had anybody from the prosecutor's office come to you and say we wanted to do a little investigation about where Thomas Hyde actually died?
No.
Thank you. No question.
Do you have anything else for Mr. Rose?
No, Your Honor, thank you.
Thank you. May you sit down. Anything else from the prosecution on rebuttal?
No, Your Honor. People rest.
Mr. Feiger, any other evidence to present? All right. Member of the jury, that means that you heard all of the evidence in the case. Before we proceed any further, I need to sit with the lawyers to take care of some legal issues here. And the lawyers have the right to know what the instructions are that I would be giving you after they make their final arguments and statements to you. So we need to talk about those also. So with that in mind, I'm going to excuse you now for about, we're going to say about 15 minutes or so break here. And again, I remind you not to discuss the case. Even though you heard all the evidence in the case, you're still not to discuss the case in any way. And to avoid any and all contact with persons involved with the case. So be available in your jury room in approximately 15 minutes. All right, you're free to go now.
All right. We go into outside the presence of the jury, the judge and counsel discuss exhibits ahead of closing arguments. So yeah, we're getting right into closing arguments, and I know that Bob Motta wanted to be here for closing arguments, so hopefully we can make that work out. I can contact him. So what do we got? Okay, yeah, so we're here. How long is this one? This one's 37 minutes. Here's closings. How long is this one? This one's 41. This one is 112, so and then here we go, rebuttal, another hour or so. Yeah, let's watch this one, and then maybe next week will be the closings, and I can see if I can get Bob on here. Yeah, we'll go ahead and go through another 37. Just now reaching noon. Thank you all again for being here. Appreciate it, guys. Wow, what a morning so far. I had to take a break. If you had to take a break, I completely understand it. If you have to take a rest through any of these episodes, trials, especially something like this, totally, completely understandable. Again, thanks for being here. Share this out. Hit that like. Helps us out in the old YouTube algorithms. Yeah, we're going to keep plugging along here. Real quick, I do want to do one little plug. If you guys use the Amazon link that I'm about to post in chat here, boom, that link right there. If you shop normally on Amazon, which pretty much everybody does every single day, if you use that link as a portal and go through and then purchase anything, it helps Publicly Buzzed on the back end. So yeah, make sure that you do that. And then as you guys are subscribed as well, make sure that you also have notifications turned on so you don't miss anything here at Publicly Buzzed, guys. We're continuing to grow, and yeah, next Sunday, I do want to do a little bit of a plug here, and I'll probably do another one also. Idaho for the series episode 2 drops 5 p.m. Eastern time. It'll be another premiere just like last week. Anybody that's going to be wanting to keep up with that, boom. I got a little bit more work to do on it. It's not complete, but I should be able to get that wrapped up for a drop next Sunday. Yeah, let's do a stinger, and let's keep moving along here just a little bit longer. We'll go to about, yeah, a little bit after 12:30. Let's rock.
Right now, Mr. Kenny and Mr. Feig, I just wanted to discuss the two exhibits that were mentioned in the defense case, and also to talk about proposed instructions, give you a chance to look at the notebook of proposed instructions, and then when you're ready, then to bring the jury back in. Mr. Kenny, you had some objections you wanted to make regarding the exhibits. Is OMP, Mr. Feiger, is that what they're...
Yeah, and
okay.
Your Honor, for the record, OMP, and they show the Thomas Hyde just before diagnosis and then a month later, and you can much more dramatically see the change in his body.
Okay, go ahead, please. Mr. Kenny, your response or objection?
Yes, Your Honor, there are already other photographs that have been admitted, defense exhibits that show Thomas Hyde's condition when he was healthy, and also a photograph that I believe indicates what he looked like within about a week, I think, or even less, before the August 4th, 1993 event. The two photographs that are proposed to be introduced at this time are photographs that contain pictures of the baby daughter. And I would submit, in light of the other photographs depicting his condition that are already admitted, that these two photographs that are admitted for their emotive effect, and that under 403 I submit that they are more prejudicial than probative, and I would object to their admission.
One of the things that have been discussed throughout this case is the condition and the deteriorating, debilitating conditions of Mr. Hyde and his reasoning, thinking, and making a decision to contact Dr. Kevorkian and ultimately to engage in that procedure. I realize there are some other things, yes, in the record, but there's been some discussion or evidence admitted as to his ability to be able to hold the child and what effect that may have had on his decision and some factors like that. I do not think that it is of such an emotional state that the value of it is outweighed by that. It shows them, I think, in one of them lying in bed, I think the child is next to him. There are covers, I think, at least up to the waist or chest area. It does show the condition. The other one has him holding a child. I think he has on a T-shirt that doesn't show necessarily the muscles condition and so forth, but I'm going to let those in. They may be used. Okay. Now, the other aspect that we have to discuss right now have to do with the instructions. I think that, well, help me out, but I think that the only major concern based on the instruction that may have been the elements C and the specific intent aspect of that. I gave the lawyers a proposed instruction that I put together yesterday. There were some comments made about it, and as a result of that, I did receive from someone, I think, that's from the defense, proposed instructions on that. Mr. Kinney, have you seen that copy of that, and do you have any other comments you want to make on that?
Yes, Your Honor. My concern with regards to the defense version, I'm trying to find it right now, is that it adds some additional words like solely that I object to. What I had proposed, Your Honor, with regards to the court's proposed instruction with regards to number 3, in terms of the elements that have to be proved beyond a reasonable doubt, that it could be reworked on the second line.
Well, isn't that essentially what I compared these earlier today, and I thought that that's basically what was done, other than maybe some additional words that are being added.
Why don't we work, if I could make a suggestion, if we could work from my copy, because I've transposed the words, and then we could argue about the words that you think I included that shouldn't be included, because I made the correction that you're talking about.
Okay. Because I had, the way I had used the words there in terms of that third, what I might call the third element, the word probably did need to be transposed, I think, because of the way that was phrased. Now,
and I guess my thought, Your Honor, was that it would be more accurate to read in number 3 that the means provided or the physical acts utilized were intended to cause death and not provided with the intent to relieve pain or discomfort and not to cause death.
What?
Okay, hold on a minute, Mr. Fager. Okay, let me just hear this, please. Okay, say that again, please, Mr. Kenny. All right, I think the way you have it phrased is, I think it's better to look at the one proposed by the defense, and then I can put those words in. You left off the word solely,
Yes.
and you added the words intended to cause death, and what was the next phrasing there?
And not provided with the intent to relieve pain or suffering and not to cause death.
And not provided with the intent
Yes.
to relieve pain or discomfort.
Correct.
And the last phrasing was?
And not to cause death.
And not to cause death. What is the phrasing of that, other than leaving out the word solely, that makes that different?
Well, I guess that was my concern with regards to the word solely, Judge. If we can eliminate that, and then I'm...
But the way the statute is written, though, that's what I've been having a lot of concern about in this particular case, and I think it's certainly that's going to probably be a lot of ink, to put to this whole issue. I think if this does get to a court of review down the way as to the language of that statute, and particularly what I perceive as a real evidentiary quagmire, based on certain cases, certain facts, and so forth. Because when you start getting into any area of intent, and where the statute tends to want to say what that is or should not be, it certainly leaves somewhat of a wide open possibilities there. And frankly, when I look at that, I think there's for a judge anyway, who has to rule on these kinds of things, some of a nightmare in terms of being able to in some way understand and control what kind of evidence comes in on that, and how the jury is to understand that. But I think my understanding, at least, of the statute is that if almost anything is done by a physician or whoever may be doing that, and whatever that procedure may be, if it is not to cause death, if that intent is not to cause death, then it's okay. I mean, that's my understanding and reading of it. I mean, you have a different reading of that?
I agree.
Okay. So why can't the jury know that that's what is meant by that they have to be able to find those things, that kind of intent, and that way it doesn't leave it in some kind of a vague area as to what that may be? Because I'm often concerned as to when jurors, for instance, if you got a possible aiding and abetting theory and you got a direct situation, as to what theory the jury actually utilized in making that decision. It becomes important sometime in terms of how you eventually rule on that for other reasons, and in terms of the evidence and so forth. And I think that what we have here is a situation where the legislature certainly does not understand and certainly does not appreciate the kind of concerns that arise in the course of a trial when words are put in, like that. But the fact of the matter is they are there, and we can't get around that. Do you have any other comments you want to make, Mr. Kenny?
No, other than, Your Honor, I think the notion of, as we have indicated before, I think that the notion of administering medications or procedures to relieve pain has to be linked to the fact that the intent can't be also to cause death. That the mere saying that I'm doing this to relieve pain and suffering is not the be-all and end-all with regards to that particular provision. Because the provision also says,
I agree with that, and that message has gotten across.
Communicated to the jury.
You see, that's well, he's saying the same thing twice. All the statute says is the intent has to be to cause death. If the intent is anything else, like relieving pain and suffering,
that's okay, just like the court said. But if your intent is to cause death, that's not so okay. So he's basically saying the same thing twice.
No, I don't think I am, Your Honor. I think that it's clear.
He's trying to link relief and pain and suffering to not causing death. If in the first clause, Your Honor, which I'm reading from my instruction, that the means provided or the physical act utilizes were intended solely to cause death and not to relieve pain and pain or discomfort. Now, Mr. Kenny wants to tack on at the end a repeating of what the first clause just said, which was, and not to cause death. And that's just repeating what the first clause said again.
Your Honor, our position in terms of reading this particular section of the statute, if someone was intending to relieve pain and suffering, but also intended to cause death, then that, in fact, is a violation of the statute. Agreed?
Okay,
But
all right.
it's a violation of the statute only because of the second part that he just said. If you have an intent to cause death, you could get convicted, even if you got other good intents, like if you have a good, 1,000 other good intents.
Well, isn't that what the statute says?
That's exactly right. I don't want what I object to is saying it twice.
I'm not sure I understand saying it twice. Okay.
He wants to say the same thing twice. The statute says that your intent, even if the statute says if your sole intent is to cause death, you could be convicted. If your intent is for something else, you can't be convicted. And Mr. Kenny says he wants you to say, the statute says if your intent is to cause death, you can be convicted, but if it's not to cause death or something else, you can't be convicted as long as you don't intend to cause death. That's exactly the same thing twice. The statute says you can't intend to cause death. If you can couple it with anything.
I agree, but I think that what that does is at the very least it clarifies the second part of that to, I think, to give the whole import of the statute that you can, in fact, do something that may be intended to relieve pain or discomfort, but if in fact if it has the ultimate effect of causing death, that can be a violation. I think that's part of the statute, and it clarifies that second phrasing that you have, right?
You put that in we put that in the specific intent part. Well, I think the court, I think I pretty much copied that correctly, and I agreed with the court's inclusion of that, because if we're going to do it in the elements, and he wants to put, and not to cause death again, I want, and not to cause death even if the medication or procedure may hasten or increase the risk of death. See, he's saying it wrong. He wants, how do you want this to, how does he want it to read?
Here's how I would see it right now, okay? That the means provided or the physical act utilized were intended to cause death and not to relieve pain or discomfort and not to cause death. Is that
but that
the
says,
essence of it?
That's what he wants. I understand that's what he wants to say, but that says the same thing twice.
It clarifies the elements, Your Honor.
I think that it does, Mr. Fike. I'm going to add that phrasing in at the last part there, but I think that the word intended solely to cause death gives it another meaning also that I think the statute, is not comprehended, by the statute, because if it says it's intended solely to cause death, because it can give it a mix. You can do something, that may be meant to relieve pain or discomfort, but in doing that, it also has with it, the intent or purpose to cause death. That's is covered by the statute also.
Well, fine, Your Honor. Well, then after, you see, he's asking you to put in this and not to cause death. I'd like you to put in the rest of the line from the statute, even if the medication or procedure may hasten or increase the risk of death.
I have no problem with that. Do you have any comment you want to make about that? Okay. No. All right. Let me make sure I get the wording of this correctly then, okay? So I'm going to take out the word solely. I'm going to add in at the end there not to cause death, and then add in the wording that's a part of the statute, even if that procedure may have hastened or increased the risk of death. Am I correct?
That's
okay.
correct.
All right. I got you on that one then. Okay. Now,
Judge, I have another. Oh, I'm sorry.
go ahead. I was going to ask about anything else.
Yes, Your Honor, I know that the court gives an instruction from the standard jury instructions regarding the arguments of the attorneys are not evidence, the questions of the attorneys are not evidence. I believe that there should be some specific mention, however, with regards to the rebuttal videotape evidence that was introduced, so that the court apprised the jury of the fact that they may consider, if they choose to, the comments referred to in the August 4th tape of Mr. Feiger as attributable to the defendant, Dr. Kevorkian. Because the court admits, excuse me,
Mr. Feigen,
please.
Okay, let's do it. I'm going to give you every opportunity to speak, Mr. Feigen, in response to that. Please, just go ahead, make your record on it, then I'll...
Your Honor, the court admitted the tape of Mr. Feiger on the grounds that it was an admission by a party opponent in an agency relationship, if you will, that Mr. Feiger was authorized to speak on behalf of Dr. Kevorkian. I am concerned about, on the one hand, the fact that that is in fact admissible evidence that the court may consider, or that the fact finder can consider regarding the issue of venue, but that bumping up against the court's general instruction that questions and comments by the attorneys are not evidence and not to be considered by them.
Unless supported by the evidence.
Yeah, and that's what I'm saying. I mean, the court can say, if you choose to believe, give it whatever weight you wish to give it. But that the comments that appear on the tape are to be viewed differently than the ordinary questions of attorneys or arguments.
He wants to select out evidence for him and tell the jury that that evidence is more credible than any other. And he's wrong on the second point. The admission isn't, there's no law that says anything I say is attributable to him. It's attributable to me as an agent of Kevorkian. There's no law in the history of Michigan that says that it's attributable to Dr. Kevorkian. The only reason it's admissible is it's attributable to me as an agent.
But, okay, just as a thought on that, though, without getting into whether or not I should give the instruction as indicated, and this may be insignificant in the whole context of things, but if, in fact, a person has the opportunity to deny the statement at the time that is made, and that person doesn't do that, and we have that agency relationship involved, isn't that what we might refer to as an adoptive admission?
No. Okay. Nothing Dr. Kevorkian did adopted it. There's no evidence here that he had an opportunity to do anything and didn't do it. This case, there's no such, that's certainly not true here, but Mr. Kenny is asking the court to do something I think would be wholly improper, that is single out a piece of evidence, highlight it for the jury, and tell them to look at that more than anything else. That's just wrong.
Well, that may not, maybe it's the wording that we're talking about more than anything else, Mr. Frank. In other words, if we get to what is the value of and the purpose of those statements, in the tape, made by you, then it becomes a question, I guess, of how, whether you should tell the jury what that means, which may essentially, help both sides in a way in terms of like what value, if any, the jury is to put to that. Because see, the other part of that, the other side of it is that there's surely the danger, I guess, if I may put it in that way, that they're going to say,
what happened?
Well, Mr. Feiger, said this, so that's not even an issue anymore. But in the context of this case, it may be an issue because they may have to still resolve or decide, whether or not they believe that this happened
Yeah,
on
but Judge,
Belle Isle.
there's an instruction that says they're to consider evidence properly admitted by the court. That answers it. So I think he's now being a little bit disingenuous when he says, well, he's worried about the other part that says statements of attorneys in court are not to be considered evidence unless supported by the evidence that's been admitted. Well, that's evidence. So he's asking you to state there's already a standard jury instruction that says exactly what he wants you to say. You are not to consider it unless it's been admitted as evidence. Now, he can stand up and say, Judge admitted this as evidence, and he's going to instruct you that you're to consider that as evidence.
And if it is evidence, of course, you can argue that it is, and any inferences that are made therefrom. But
That's right.
The objection is, should it be, and if it is to be singled out as something significant or special based on other rules of law, how do you word that without giving it that wrong impression? That erroneous impression, maybe.
And he's worried that that the instruction that says arguments of attorneys are not evidence. That's not this. I think he's being not really even honest with the court. That thing that you admitted as evidence isn't arguments of the attorneys here in court. That's evidence.
Okay, I see your point. Go ahead.
The judge, when you give that evidence instruction, you tell them what is evidence, and you also specifically enumerate what isn't evidence. And one of the things you enumerate as not being evidence are the comments of the attorneys, the questions of the attorneys, the arguments of the attorneys, so that the jury is focusing on the fact that in terms of their deliberations and what they can consider in resolving issues, it's not what the attorneys say. And that's my concern.
Yeah, I understand that. I would tell them, that all of the exhibits that have been admitted into evidence and what's contained in those exhibits is evidence in the case. I think that instruction has to do with the matters that are in the questions and the arguments, that are in here. And I think whether that's clear or not, I don't know. But
I
it will be told that that's
can I?
Well, you can argue that, yeah,
Okay.
because you're talking about what's in evidence. But I don't want to. I would agree with Mr. Hyde with that. I don't want to give an instruction, that's going to focus on away from that or focus any attention on that should not be there. So I would not give any kind of instruction different from what I would ordinarily give on that. Okay. Anything else, Mr. Kenny?
The other issue, Judge, is I think we need to discuss the designation issue.
Okay. What do you want to say about that?
Your Honor, I believe that that the designation order should be introduced and it should be read to the jury. The jury should be apprised of that. We are not talking about a jurisdictional dispute here about whether or not this court can at all hear this case. The question of the locale and where the case is to be tried. But as the statute talks about, the Attorney General makes that designation, and that designation is made known. I think the statute even makes reference to the fact that the crime can be charged in the information or the indictment, and the Attorney General can designate where the prosecution is to take place. If we were to look at an analogous situation, if a homicide had taken place and it was totally impossible to determine which county in the state of Michigan the homicide occurred in, and the Attorney General designated, let's say, Wayne County, if the jury were not apprised of the fact that venue had been designated, it would seem to me a jury could go in and return a not guilty verdict on the grounds that, how do we know where this took place? And so it seems to me that not...
But what makes you think, that the designation, by the Attorney General, forecloses the jury considering that?
Right. Oh, it doesn't. It doesn't. But I think that it becomes almost sort of like a rebuttable presumption, if you will, that if it's before the jury, that they can be apprised of the fact that the Attorney General has made such a designation of the venue of this case being Wayne County for purposes of this prosecution.
But they,
Because
hold
otherwise,
on a minute. I give you a chance to speak. Mr.
Otherwise, it doesn't mean anything.
But maybe it doesn't. That's what I'm trying to understand. Whether it does, mean anything. And so maybe you're right when you say that. But I understand you certainly are saying more than that. But the point that I'm trying to make about that is that let me put it this way. I read the statute, and let me find the exact wording of the statute that we can know what we're talking about here. It says that, and I quote, 762.3, if it appears to the Attorney General that a felony has been committed within the state, and that is, it is impossible to determine within which county it occurred, the offense may be alleged in the indictment to have been committed and may be prosecuted and punished in such county as the Attorney General designates. And it goes on to say that the state should bear all expenses of such prosecution. Now, in this next sentence here, the wording of it kind of escapes me a bit, but it says the responsibility in the authority with reference to all steps in the prosecution of such case should be the same as between the prosecuting attorney of the county so designated and the Attorney General, as though it were an established fact that the alleged criminal acts, if committed at all, and I emphasize that, were committed within that particular county. But the wording authority with reference to all steps in the prosecution of such case shall be the same. Now, how and if you take that...
between the Attorney General and the prosecuting attorney.
What is that?
In other words, Judge, what I'm saying is that if you can't determine where it's going to be prosecuted, if it's impossible to make that determination, and Frank Kelly indicates that it should be designated for venue in Wayne County, then John O'Hare bears the responsibility of going forward and prosecuting it, even if John O'Hare were to throw up his hands and say to the Attorney General, I have no idea that this happened here in Wayne County. Why should I be the one to prosecute it?
Now, you got your copy of your order, Mr. Kenny?
Yes.
That came from Mr. Kelly?
Yes.
That your third paragraph on page 1, you have a copy, Mr. Fager, Henry? You have a copy of the order? Okay. The third paragraph of that reads, and I quote, now therefore, in accordance with MCL 76.3 and the parallel citation MSA 28.846, I do hereby designate the County of Wayne, State of Michigan, as the county in which the perpetrator of said felony shall be prosecuted and punished, and that the County of Wayne should bear the burden and expense of prosecution of this cause. See, that wording, and I think that tracks the statute, has to do with the county to be designated as the place for the trial to take place as against designating the venue of the particular offense. And that's where I think you have to see the difference, understand the difference, because if the Attorney General is going to essentially by such designation say this is the venue of the offense, then that the weight of that particular part about proving where it occurred has no meaning. I have not seen anything in the case law, and I readily admit my search of this, as shows that there's very scant case law at all on this. But I understand that the history of the statute has to do basically with where you have those situations where it's not clear from the very beginning, maybe at some point, say when they say Oakland County or Wayne County is trying to put together a prosecution, and there's some question as to whether or not the venue of the offense, which usually determines the status of the jurisdiction as to where the case is to be tried, where the venue, the actual place of the offense is not clear, and therefore the Attorney General has to step in and almost, if I may use that term, kind of settle the argument between, say, the Wayne County prosecutor and Oakland County prosecutor, and say, hey, I designate this is the place that this is going to be tried. Otherwise, I see that cuts into, or would possibly cut into, the province of what the jury usually has to determine. I don't think that we can sit here and say, that the Attorney General has that kind of an authority by making that kind of designation. And that's how I weigh this out, and that the danger that I see in making any other comment to the jury or admitting that as an exhibit to go to the jury, that the order and the designation would cause, that kind of a confusion, in terms of what they might do. Because right off, if they see something with the Attorney General's name signed to it, they're going to say, well, that issue is resolved. I mean, the Attorney General has said that this is where it happened, so therefore we don't have to worry about that.
Okay, that may very well be the case. That may be the practical effect, but let me pose this to you. With regards to the hypothetical that you posed, the one about two counties vying for the same case, that's one circumstance.
Well, vying not to have it.
Right. But there are plenty of other cases.
Which might have been a good reason for this one to go somewhere else. But anyway, go on. Please.
There are any number of instances where you can't determine where it happened. And if venue is to be proven beyond a reasonable doubt, if that's one of the elements and that's one of the instructions that's to be given to the jury, and the Attorney General is satisfied that it's impossible to determine, then any gesture of going forward and prosecuting would be futile. And then the statute becomes...
That may very well be, but see, that's one of the problem, I guess, that you have sometimes when you can't prove that somebody committed a crime or somebody, you got the right person, or all kinds of things that might occur when the prosecution's case, can't meet whatever it has to meet, Mr. Kenny. That's there. Now, if we give the prosecuting attorney and Attorney General the authority to pretty well dissolve that, by saying, well, we'll say what this element should be, then you got the same kind of concern. Because I feel your argument is that, well, if it didn't have any effect, what would be the reason of going? The prosecution still has to prove the venue of the offense, I think. This is just a kind of a convenient way of like saying who is going to have the responsibility of trying to prove that.
I understand the court's position.
Okay. So I don't think we need to go, much further, with this. Mr. Feige, if you have any other comments you want to make out here now.
The court's correct. The Attorney General couldn't possibly take away an element of proof.
So basically, based on the record that's been made here, and my reading of the statute and the case law, on this, I'm not going to allow this. Now, there was, let me see. I think there were a couple of cases that were cited in the as part of that particular statute, and like I say, there's a very scant case law on that. There's really any much guidance, from that, but. As I said, when I weigh the possible effect and what you would argue it should be the reason against what it might do in terms of the jury issue there, I think that it has to weigh in favor of that not taking the jury function away from them. But anyway, I'm not going to, I think that right now we're not going to say anything about that. I'm not going to admit it into evidence. I think it has no real reason to be mentioned at this particular time as to what the Attorney General did. And that, frankly, in the context of this particular case, this case anyway, I don't think that has any real function, I guess, of having this, except for whatever satisfaction, I guess, it gives their respective offices here in Oakland and, in Wayne County as to, where the case, would be tried. Let's say, for instance, and I'm going to leave this alone because I think I've already ruled sufficiently on it.
Leave it alone.
But just take this for example. Let's say if after this case has started, that Mr. Kelly had said, well, maybe it should go to Oakland County. They have better facilities or better courtroom or whatever those reasons, may be. And he designates, Oakland County as the place, for this. Could you do anything about that? Could I do anything about that? But in the
clearly not in light of jeopardy.
Right. Okay. Couldn't. Well, not. Well, let's just forget about jeopardy for the minute. Okay. But just in terms of the practical aspect of designating a place, for it. Or let's say that this would happen before trial started. If he had designated Oakland County as the place, and everything else might point to it being Wayne County at Belle Isle, would Oakland County have a problem trying to prove that? Or would the designation by the by the Attorney General settle that issue? That's the question I pose. Okay, I don't look for an answer; it's rhetorical. But anyway, I think that's part of the reason that I use here. But I'm not going to allow anything else to be said by that. It's already designated in the information as being Wayne County. And of course, if it was the reversed, I guess it wouldn't be here. I wouldn't have to say anything about that. But say, for instance, if this had been initially in Oakland County, and then for whatever reason, moved here, and it was initially stated that it happened differently, then I think the jury would have to be told about that change. But here it's already there. The Attorney General's designation is consistent with that, and that's the venue still is left as part of the elements that's in there. So that we'll pass that right now. Is there anything else from the prosecution side?
Yes, Your Honor. I would request the court make a ruling in limine with regards to closing argument regarding any comment by the defense about penalty. Know that there was questions, at least one question posed to Dr. Kevorkian on direct examination about.
I think that there's ample case law that says that that you can't talk about penalty. I mean, general things as to a person's freedom being possibly taken away, or that kind of thing.
I might reference his freedom being taken away or something, but I'm not going to reference 1 to 4 year felony.
Yeah, that's what the case law I think basically says. Okay, and then that it has to do with anyway. So that's clear. Anything else from the defense? I mean, from the prosecution side?
No.
You know what? I'm going to sit in that jury and have them come back at 1:30. We could have. I thought we would have been into arguments by now, but have them go and come back at 1:30. Okay. Go ahead, please.
Nothing further, Your Honor.
We still have the specific intent instruction, Your Honor. You probably want to take
as I know, Mr. Kenny has not said anything in response to that,
okay.
So I have no problem with what's there. Okay.
Right.
All right. Okay. So I take that as offered by the defense.
Thank you.
Okay. Anything else?
No. Are we going to list what instructions, or do you have a package?
Yeah. What I do, I got a notebook here, and I think I have in here the ones that I will be given. I'm going to just give you the entire notebook for you to look at, and then if there's any concern about that, when we get back from our break, then you can let me know.
Thank you.
Okay. I intend to give it as there in any order that's there.
Thank you.
Okay. All right. I'd like to have the lawyers back here about say 1:25, so we can make sure the instructions are okay. All right. Okay. Thank you.
All right. We are going into the prosecution delivers their closing arguments. So yes, hopefully I can get Bob on here next week. I need to check with his schedule, see if that'll work out. I know he wanted to see the closing arguments, and that would be awesome to have him here, to have an actual defense attorney in the house, Bob Motta, to help us out. So we'll see what's going on. But yeah, wow. Incredible morning, super difficult morning, trigger warnings all around. Wow. Yeah. I don't know how any jury could ever see anything from this trial, quite frankly. If you go back to Calvin Thurman, the hospice nurse, but much less Heidi Fernandez, the fiance of Thomas Hyde. How could you see her testimony for, well, that was difficult. That was over an hour and a half of her up there giving painful details about the end of the life of Thomas Hyde, basically from the beginning of the disease to the literal last day, and ever convict Dr. Jack Kevorkian. You can't. It's crazy. It's madness. And yeah, the judge was kind of pissing me off multiple times during this one. So, and I like this guy. I've liked him so far. But I don't know how anybody could watch that and ever convict him, which, you can go and look at the outcome of this. This is from 1994. Multiple, hell, we know there was 7. There's only 3 here on court team, but there were 7 times they tried to put this man in jail for this. It's insane. Oh yeah, I went down that rabbit hole also, Yella. And I would recommend anybody read up on the beginning of Dr. Jack Kevorkian's career all the way until the end of his life. Always an incredible guy. Did nothing but want to help folks. Awesome guy. Yeah, thanks guys so much. Appreciate it. Next time you'll see me will be Tuesday, 9 p.m. Eastern time. Be covering something. We'll see what's up. One thing I want to plug here real quick. Again, Sunday coming, it'll be episode 2 of the Idaho 4 series that I'm working on. Here is episode 1. If you have not seen it yet, please go check it out. Give it some love. Give it a like. If you have already watched it, watch it again. Watching it through for a second time will only help it in the algorithm. Please help us out. Appreciate it, guys. Love you guys. Yeah, incredible morning. Enjoy the rest of your Sunday. We'll start this week out strong. I'll probably see you in the morning with Jay. Let's go. Love you guys. Let's get out of here.